We are on the record for State of Florida versus Calvin Riley, 23 CT 845. Is the state ready to proceed?
Yes, Your Honor, the state is ready to proceed.
Defense ready to proceed?
Yes, Your Honor.
Okay, I do notice that we do have a lot more folks in the courtroom than we normally have, and we have some members of the media. So I just want to remind everyone to please be courteous to the process. Please do not make any unnecessary noises or go in and out of the courtroom repeatedly. That is disruptive, and it will affect the ability for us to conduct a trial. For the members of the media, can you all just raise your hand so I know who you are and where you are? All right. Welcome. I just ask that you please do not take any pictures or video of the jury. Everything else is fine with me, and please just try not to be disruptive. I know that the defense has filed a motion last night. Do you wish to be heard on that motion this morning?
Yes.
All right, you may proceed.
Your Honor, before we proceed with argument, the state does object to having this motion heard.
Okay, and what is your objection?
Well, for starters, Your Honor, pursuant to court order that was previously filed, pretrial motions are supposed to be filed within the 5 days before jury selection is supposed to occur. In this specific case, the defense waited the day before specifically 1 hour before business end of hours for the business day. The state has not had the opportunity to thoroughly research this issue, and the state would also argue that it should be stricken based on the principle of res judicata. They've already addressed whether or not the liquor bottle that was found in the vehicle was a violation of due process. They're raising another violation of due process for the exact same issue. It's already been established. If this was their concern, they should have filed that far earlier in the process.
Thank you. Any response?
Yes, Judge. First of all, res judicata is not applicable here because the motion previously filed was a motion to suppress, which goes to the lawfulness of the evidence and the damages that flow from that. This is actually asking you to dismiss, which is a completely different remedy sought. So that's not applicable. The motion to dismiss is based on fundamental due process grounds. Non-waiver of fundamental due process grounds is specifically accounted for in 3.190C. It is timely. With respect to the trial court order, respectfully, a trial management order does not supersede the rules promulgated by Florida Supreme Court. So it is timely. We would ask that it be heard.
All right, I'm going to allow it to be heard. You may proceed.
Thank you. First, Your Honor has a copy of the motion.
I do.
Thank you. There's not a lot of case law that addresses this specific scenario where a police officer essentially manufactures evidence and then plants it.
And that's what you're alleging happened here.
That's what the video shows, Judge.
That's your opinion of what the video shows, but that's what you're alleging happened.
So a full bottle that is sealed is not evidence of a DUI.
Okay.
There's nothing has been drank. A open bottle is evidence of a DUI. An open, and you can see her clearly open it, as you stated during the motion to suppress. A sealed bottle, it's worse than that though, it's a sealed bottle that is open, poured some out, not all, but some, and then thrown back in there. It's worse than that though. After that point, the dishonesty to the other officers about what was found. So I would object to the notion it's an opinion. We see it. It's been clearly seen on the video, her own video. So there isn't a lot of case law surrounding this scenario. I think for two primary reasons. One, it is particularly egregious. This level of police misconduct is not, we hope, often seen. But I think, two, the times where it is this egregious, it does not often go to trial. So we're forced instead to look through analogy. Egregious government conduct is a basis for dismissal. We see that throughout the entrapment case law. It stands to reason that if the government cannot induce you to commit a crime when you're not otherwise predisposed, they cannot create a crime where none existed. That is the basis, and that's our argument.
Okay. And before I let the state respond, I do want to address the timeliness of the motion as far as when it was chosen to be filed. So when did your office first receive the body cam footage?
One moment. I believe it's November 6, 2023.
Okay, it's November 6, 2023.
There was a prior one that Axon link that was sent, but it did not contain the footage at issue.
It looks like the motion to suppress was filed on February 16th, 2024. And we had a motion hearing (2027). So my question is, why did it take until the eve of trial, after we picked the jury, for your office to then decide that this behavior was so egregious that it required a motion to dismiss to be filed? Why didn't you file one on November 27th, the day after you received the video and were able to review what you have been arguing is so egregious that you want this court to dismiss the charges?
So what Your Honor is inquiring goes to a trial strategy matter. As far as you're inquiring as to matters which I cannot.
So your strategy was to pick a jury and
Well,
then file a motion to dismiss?
As far as what leads to the timing is squarely a trial strategy matter. Now, I can also say I filed this motion, and I have not been on the case since November. I have been on this case this week. So that is something the court should consider as well.
Okay. When did you have a first chance to review the video?
This is my court week. I've handled upwards of 80 cases. I'm also a division chief, so I'm responsible for several other attorneys. I had the first opportunity to look at the footage in full yesterday. I promptly filed the motion.
Okay. State.
Yes, Your Honor, there's a few different matters the state would like to address regarding the defense's argument. First, under the Florida Rules of Criminal Procedure, specifically 3.190C, subsection C, time for moving to dismiss is supposed to happen before the indictment or information or before or at arraignment. The only time that it should be heard outside of that period is when it's special set by this court. The defense, from my understanding, never once reached out to the court and asked for us to have this hearing set until the eve of trial yesterday.
That is a misstatement of law. There are 5 circumstances within Florida Rule of Criminal Procedure 3.190C that are able to be heard at any time. 4 are enumerated, and the 5th is based on fundamental grounds. That is the plain text of the statute, or the rule.
Your Honor, if I may actually complete my argument, as I was going to say, the state recognizes that there is discretion in allowing it to be heard. However, in this situation, the defense didn't reach out and ask for it to be heard. They didn't ask for the court's discretion for it to be heard. They just rather sent an email saying it to be set.
Sit down and let her finish her argument.
I'm not interrupting, but I will sit down.
Additionally, Your Honor, so not only is it the state's position that this motion was untimely, but we also know that there is an order based on this court that's published online for rules of conduct in this exact courtroom before Your Honor. That proceeding and the order that was filed for the jury selection, I cannot emphasize enough, states that pretrial motions are supposed to be filed before jury selection. Next, moving to my next argument as it relates to objective entrapment, this is an issue that, like the defense says, has not been handled for a case of this fact pattern. And the reason for that is because the police conduct at issue in this case is not so egregious as they are calling it to be. Simply put, the Florida Supreme Court has ruled in terms of what objective entrapment is, and if I may just have a moment, Your Honor, to locate my case on that. The Florida Supreme Court in State v. Lawson, which is citation 462 Southern 2nd 182 or 1082, and that's from the Florida Supreme Court. I have copies of this case. My approach and tender.
Yes, you may.
Yes, the state has copies for the defense as well. The Florida Supreme Court, in ruling and identifying when the existence of objective entrapment occurs, has turned to state Supreme Courts all throughout the nation. In particular context, they have in this opinion from State versus Lawson, they refer to a case called People versus Hohenson, which is from the Missouri Supreme Court. They stated in that case that the strength of the connection or the causal relationship between the challenged government conduct and the commissions of the act for which the defendant stands convicted is an important consideration. Additionally, another case out of Florida's 4th DCA from 2005, this is State versus Blanco, citation 896 Southern 2nd, 900. That case also specifies that the objective entrapment, or the standard for objective entrapment is irrelevant to a defendant's subjective perception as to what happened. So it's the state's position that first, this case, what happened in it, law enforcement, we've seen in previous hearings, we've seen suppression hearing, we've seen the deposition video. When Officer Oliver first approached the vehicle, she noticed multiple signs of impairment. The defendant was traveling at a high rate of speed down Monroe Street at nearly 2 a.m. in the morning with no headlights on whatsoever. Based on where he stated he was coming from, that would mean he was traveling at least 5.5 miles with no headlights on, not realizing it. Officer Kirsten Oliver told us during these suppression hearings that she noticed things such as his inability to recognize that the headlights were on. It took her going and showing him, turning the dial, that the headlights were actually off. He wasn't able to locate his documents. He couldn't find his ID. He couldn't find his registration. It took him several minutes to actually try to find those items. He had glossy eyes. And there was additional factors such as Officer Muth, who told her that he was at a bar that night. He admitted to drinking alcohol that night. And this all occurred before he was placed under arrest. It's not until after the defendant was placed under arrest and put into the patrol vehicle that they actually conducted a search of the vehicle. At that point, he was already under arrest for the crime. They did not manufacture anything in that moment when they decided to arrest him. The alcohol bottle was not found until after he was already arrested for DUI, and that state cannot emphasize that enough. Now, the defense cited to another case in their motion to dismiss, I believe that was Williams versus State, and they're trying to equate opening a sealed bottle of liquor with the idea of law enforcement manufacturing cocaine. This is nothing of the sort. Manufacturing cocaine is not comparable to opening a sealed bottle of alcohol and simply dumping it out. And it does not take away from the fact that the defendant had that liquor bottle in his vehicle at the time he was arrested. This is not a situation where they pulled it out of thin air and put it in his vehicle. It was already there. The state would submit that this is not egregious police misconduct based on a violation of due process. The defendant is not charged with an open container. He's charged with driving under the influence. And when we look at the probable cause in this case, we know that what they based their decision to arrest him on was not based on that liquor bottle in his vehicle. It was based on the signs of impairment while he was driving. So for that reason, the state would ask that you deny the defendant's motion to dismiss.
Okay. Response?
Yes, Judge. We would also cite this case. The state cited it. It looks actually pretty good for us. Where an informant is paid a contingent fee, due process cannot abide. That was upheld in this case. It's much worse than getting paid a contingent fee. She's saying it's not pulled out of thin air. That's true, but the criminality aspect was pulled out of thin air. There's nothing illegal about having a bottle that is closed. There's nothing that indicates DUI about a bottle that is closed and sealed and full. There's really no question factually that you can see you can hear it poured out, you can hear the bottle open, you can see that it's full before, and you can see that when she throws it back in, it's not full. I think the conduct is egregious. You have the authority to dismiss it, and you absolutely should dismiss this case. Thank you.
All right, so as I think both parties have pointed out, the actions that are at issue here are all observed on body-worn camera. I do want to make sure that the defense would stipulate that there were signs of impairment and he was under arrest before the bottle was found.
Judge, we don't intend to stipulate to any element of this.
Okay.
Respectfully.
And I get it, I understand. So we've already had a motion to suppress on this. where at that motion, the officer who sees the bottle testified. I think at first she testified that she believed that the bottle was open. We played the video for her several times. We turned it up very loud so that she could hear it, and she said, it sounds like I might have broken the seal, and I poured it out. That's what the court thought they heard. And I think at that time I said that it will be up for the jury to decide what they think happened. I don't find this analogous to law enforcement officers taking powder cocaine and creating crack cocaine to then sell in a reverse sting. I don't see this analogous to an entrapment where there was no crime and they induced the defendant into committing a crime. By the testimony and the evidence that we've heard so far in the previous hearings, there were reasons for them to pull over the defendant. There were signs of impairment. There were admissions that were made by the defendant on body-worn camera that we can all hear. And after the defendant was placed under arrest, the officers found a bottle in the car, opened it, and poured it out. As I stated in the motion to suppress hearing, the jury will get a chance to view that video. Both sides will get to examine and cross-examine the witnesses about what happened on that evening. The parties can make whatever arguments as to the theories of the case and what they believe happened, but this is ultimately a decision that should be left to the jury. This is not a situation that requires the court to dismiss the charge at the 11th hour. This is behavior that was captured on video. The jury can make their decision as to what they believe happened. There is a disagreement in the courtroom between the two parties as to what happened, and that's why we have the judicial system and why we have the jury system. It's for both parties to present their evidence to the jury and for the jury to decide what they believe happened on that day and whether the state has proven their case beyond a reasonable doubt. So I'm going to deny the motion to dismiss. Before we start trial, though, I think we have another issue that we need to address.
Yes, Judge, the Richardson issue.
A Richardson issue?
Yes, I believe Ms. Desiree will be handling that. I assume that's what,
I was going to talk about we need to bring the jurors out one by one to make
okay.
sure that none of them have read or seen anything about what has been in the media since we had our jury selection before the media coverage started.
understood.
But what Richardson violation are you alleging occurred?
Your Honor, yesterday afternoon, the state sent an email saying that this was their notice to the defense that they intend to bring an entirely unrelated witness as a rebuttal witness, Officer Gary Roy. He is in no way involved in this case. He was never listed on any answer to discovery. We have no idea what they're even thinking he's going to be testifying about in regards to this case because he's in no way related to this case. Also this morning, the state emailed me saying there was also their notice to the defense that despite never being put into an answer to discovery, that they intend to present certified judgment sentences of my client.
Okay. State, if you can tell me the purpose of calling Officer Roy and why the late discovery?
Yes, Your Honor, it wasn't the state's original intent to call Officer Gary Roy to the stand. However, given the press and the defendant's own statements in the media, the state believes that it's necessary that only as a rebuttal witness, if there's any question as to what the policy and procedures are when it comes to DUI investigations, that's all he would testify to. We understand you can't talk about the substance of the case within itself, but it's only related to policy and procedure.
Okay, what specific comments that were made in the media by the defendant?
It's more or less the contents of the media publications. There's been numerous accusations that there's this policy, Order 42, that it does not include a subsection related to alcohol. The state understands that there is not necessarily a subsection within Order 42. However, the state has located the correct policy number, and the correct policy number does confirm that that policy exists. It's also a rebuttal witness, Your Honor. We're not intending to introduce him during our case in chief.
Defense.
Your Honor, we believe the remedy would be just a simple proffer before they present him.
Okay, so if we get to that point where we need him, we can do a proffer. And are you still asking for a Richardson hearing or?
Yes, Your Honor.
Okay. So for the purposes of the Richardson hearing, I don't find that it was a willful withholding of information, that it was inadvertent based on the developments that have come. That's why there was a late disclosure. I don't find it to be substantial, and I, at this time, don't find that you're prejudiced, but I'm willing to, after there's a proffer, we can revisit it and talk about that. And what was the other thing?
Your Honor, the state this morning sent me an email regarding the certified judgment advances.
Okay, and how does the state intend to use those?
Your Honor, we only intend to use that. We don't expect the defendant, of course, to take the stand unless that's his right to decide to take the stand. That's only impeachment evidence. We're not intending to introduce it as a physical piece of evidence.
So it's just if he took the stand.
If he takes the stand, it would be used for impeachment. Additionally, we would like to point out that this is the defense. They should know that their client has these convictions on their record. It's public record. It's in the clerk of court system. I believe it's local. So that's something that they would have had knowledge of far before today.
Thank you. Are you still objecting to the,
Yes, Your Honor.
on what basis?
Late disclosure, literally on the morning of trial, Your Honor.
Okay, so I don't find a violation. I don't really even think there's a need for a hearing based on how they're going to be used. But I don't find that it was a willful violation. I find that it was inadvertent, and that there's no, it's not substantial. There's no prejudice to the defendant. Okay, would you like to bring the juror? I think we need to bring them in one by one. Does anybody object to that?
We would agree that to the extent that the inquiry needs to be made, that they be brought, the individual. I will say that Your Honor's already ordered that they avoid anything related to this case, and there is as of yet no indication from anyone that they have not obeyed that order. So I'd like to put that out there. But to the extent the court feels it's necessary to inquire, we would ask that the individual. We would agree.
Your Honor, the state would be requesting that each individual juror is pulled. Given the publicity of this event, it's nearly impossible to open any social media platform, whether it's Twitter, Facebook, Instagram, without it popping up. It's not something that you can just avoid seeing. It's additionally, this trial date has been published all over social media. This is the only DUI trial that's currently going today. I think it's a reasonable inference that somebody may have received a message from loved ones or friends saying, hey, I heard you're in a DUI trial on Friday. Is this the case that you're going to be hearing on? So we would be requesting them to be pulled.
Yeah, I think that based on the headlines that I've seen, someone may inadvertently click on it, not realizing that it's the trial that they are a juror on, and then start reading it and realize that it is, in fact, the case that they've been called to serve on.
Understood.
All right, so if we could just bring them out one by one by jury number. They can just sit in that first.
All rise, juror entering the courtroom.
Good morning, sir. You can have a seat. You all be seated. So, welcome back.
Thank
If you can pull that microphone a little bit closer to you, just so I'm not to ask you some questions.
you. Yeah.
So, you were selected for this jury on Tuesday.
Yes, sir.
And at that time, I asked you to not do any research or look up anything related to the case, correct?
Yes, sir.
Since then, I've been made aware that there have been reports in the media related to this case. Have you seen anything or read anything pertaining to this case or Mr. Riley?
No, sir.
No. And you haven't seen anything or been sent anything from any family members or seen anything on social media?
No, not.
Anybody ask any questions about your jury service?
No, sir.
Does the state have any questions?
No questions from the state, Your Honor.
Defense have any questions?
None from the defense. Thank you.
Thank you. You may be seated. Good morning, sir.
Morning, Judge.
So we selected you for this jury on Tuesday, and at that time I instructed you to not look up anything or read anything related to the case. Do you remember that?
Yes, sir.
Since that time, there have been stories published about this case in the media. Have you read anything or seen anything related to this case of Mr. Riley?
No, sir.
Have any family members or friends sent you any email or text messages or called you and talked to you asking you about this case?
No, sir.
Any questions from the state?
No questions from the state.
Defense?
None from the defense.
Thank you, sir.
Thank you.
Your Honor, is there an issue raised before Commissioner?
I'm sorry? You want to go sidebar?
Yes, please.
All right, you may be seated. Morning, sir.
Good morning. Morning, Judge.
So when we selected the jury on Tuesday, I asked you guys not to read anything related to the case. Now, you're not in trouble for anything. I just need to ask this question to make sure.
Sure.
Because there has been some media coverage of the case since Tuesday. Have you read or seen anything related to this case or Mr. Riley?
No, sir. My TV actually has been on the blink, and I've been watching movies for several months, saving for a new TV. Just haven't went and bought one.
Okay.
Haven't
I'm
really
sorry to hear
watched
your
it.
TV's been on the field.
Well, it's good and bad in that.
And has any of your family members or anybody asked you anything about this case or?
No, I've only got a couple of sisters and brother left. Most of them have passed.
Well, thank you, sir. Thank you for coming out and answering my question.
Yes, sir. Thank you.
You guys can stay seated while the individual jurors are coming in and out. I appreciate it. You can just have a seat now first, Jeff. Okay. Good morning.
Morning.
You're not in trouble.
Okay.
When we picked the jury on Tuesday, I asked you guys to not look up anything or read anything related to the case. Do you remember that?
Yes, sir.
You're not in trouble, but we just learned that since we picked the jury, that there have been reports in the media about the case. So I'm just trying to find out if you've seen or read anything related to the case.
So I didn't look anything up as instructed, but I did see it.
You did see it?
I did see it.
And what article did you see?
It was it was a video.
A video?
Yes, sir.
And what happened on the video? Were there, is it just a video? Were there any comments that were being made over top of the video?
I mean, it was like body cam footage.
Did it have audio that was
Yes.
attached to it?
Yes, sir.
Okay. Did you, when you saw the video, did you realize almost immediately that it had something to do with the case, or did you have to watch it a little bit?
Not right away. Not right away. I didn't realize. I watched it a little bit, and I was like, "Oh no!" And I put it down. But unfortunately, I did see it.
Did
So,
you see it on social media?
Yes.
Do you know about how much of the video you did watch?
I maybe a half of it, maybe a good portion.
And I'm going to let the attorneys ask you some questions, and then I might have some follow-up questions for you, but they're just wanting to know if your ability to be fair and impartial has been altered by seeing the evidence before it was presented at trial, okay?
Okay.
So I'm going to let the state ask some questions.
How are you doing today?
Good. How about yourself?
I'm doing good. I just want to make sure, same thing with me, nothing you say is going to get you in trouble here. We just want you to be honest with us. So you said you watched the video. Was the video that you watched, did it include narration from a journalist?
It was like, I mean, it was body cam footage, so it was the officer. I could hear the officer speaking.
Okay. Was it accompanied with an article?
Not that I'm aware of.
Okay. What platform did you see this on?
Facebook. Like, it just popped up on my feed.
Okay. Did you see any comments as to the actions of the police officer in that video, or accompanied with the social media post?
No, I didn't read any comments.
Okay. Did you read the initial post about whoever posted it?
Yes, because it was at the top,
Okay.
like the.
Can you tell us what that said?
At the top it said TPD officer plants evidence.
Okay. When you saw that, would that affect your opinion in this trial, your ability to view the evidence?
I don't think so. No, because again, that's not the whole story. Maybe there's more that I'm not aware of.
Okay. So it's fair to say that you can still be fair and impartial through this process?
Yes, ma'am.
Okay. Nothing further from the state.
Defense?
Moment to confer.
Yes.
No question.
Okay, thank you, Mr. Owens.
Okay.
You can go ahead and go back. Please don't discuss anything that we've talked about or anything that you've seen with the other jurors, okay?
Yes, Your Honor. Thank you.
Sorry. Good morning, Mr. Ramirez. You can have a seat in that first chair. So you're not in trouble in any way. You're just asking some questions. On Tuesday, when we picked the jury, I asked you guys to not read or look up anything related to the case. But since then, I've been made aware that there have been some articles on the internet related to this case. So I'm just trying to find out if you have inadvertently seen or read anything related to the case.
No, I have not.
Has any family or friends reached out to you asking questions about the case that you're going to be sitting on?
No.
Any questions from the state or defense?
Nothing from the state.
Nothing from the defense.
Thank you, sir. You can go back. Morning, Mr. Green. You can just have a seat in that first chair in the jury box.
No, Mr. Green?
I'm sorry.
So good morning.
Good morning.
You're not in trouble in any way. I just need to ask you some questions, okay?
Let's go.
On Tuesday, when we picked the jury, I asked you guys to not look up or read anything about the case. At that time, I don't think there was anything to see or read, but since then, I've been made aware that there are some articles out on the internet about this case. I'm just trying to find out if you may have inadvertently seen or read anything related to this case.
Yes, Your Honor. This morning about 5 a.m.
Okay, and what did you see?
I seen the evidence that was being presented in this case and how it was presented when I came here as a juror.
Okay, and can you just tell me exactly what you saw? Was it an article? Was it a video?
It was a video. They were showing where you had an officer placing an item in a car, and that was it.
Did you read the article that was related to the video?
Well, yes. To be honest, it all started coming back to me very vague from the first day I came in here, and then all the questions I might have had became a little answered by that.
Okay. And do you know where you saw it? Was it on your?
It was on TV, ABC 27.
Okay, so it was on TV.
Right.
But did you find any articles on the internet about it, or you just saw it on the news?
I just saw it on the news this morning.
Okay.
That's it.
All right. So I'm going to let the state and defense ask you some questions, and I might have some follow-up questions.
All right.
Okay. All right. Ms. Hershey.
No questions from the state.
Spence.
Moment first. No questions.
Okay. Well, I have some questions for you if they don't. So you said it answered some questions that you had about the case?
Yes.
Okay. By seeing what was on the video and what was being said, did you form any opinions about the case or the evidence?
Well, yes, Your Honor.
You don't need to tell me what they were. I'm just asking if you formed an opinion.
Yes, I did.
Do you think that that would affect your ability to be fair and impartial and give both sides a fair trial today?
Okay, now that's a good one. But I have to give it to you like this here. You told us to stay focused on what's being presented in front of us by law. Okay? But then you see the outcome of it. And when I say the outcome, sir, I'm talking basically about what I seen this morning on TV. And I'm going, I thought this was supposed to be a low key in my mind. And then when I learned the impact and the nature and the evidence that's being presented, all that wasn't talked about when we were choosing jurors. So yes, it does have a change on you as far as making a decision.
Okay. Well, thank you very much for your honesty and thank you for being here.
Thank you.
Good morning, Ms. Jones. You can have a seat, thank you. So you're not in trouble in any way, I'm just trying to ask you guys some questions. Because when we talked on Tuesday, I had asked everyone to not read or see anything related to the case, but it's come to my attention that since Tuesday, there have been some reports in the media relating to this case. So I'm just trying to find out if you may have inadvertently seen or read anything about it.
I haven't,
Yeah.
not at all. Clueless.
And have any family members or friends reached out to you asking you any questions about the case?
No.
All right, I don't think I have any more questions. I'm going to
Okay.
take the state of defense. State, do you have any questions?
No questions from the state.
None from the defense.
All right, thank
Okay.
you, ma'am.
Your Honor, I just wanted to make sure, I don't believe I announced myself on the record earlier, so for record purposes, Emma Hershey, certified legal intern for the state. I'm here with 2 additional attorneys.
Garrett Hartman on behalf of the state. Eric Trombley on behalf of the state.
Thank you. I'm not sure, Mr. Henley, if you announced yourself, but you guys
I'd be
can
happy
go
to
ahead.
do so. Again, Eric Henley on behalf of Mr. Riley.
And Desiree Goodfellow on behalf of Mr. Riley.
Thank you. Okay, so we have 2 jurors that have heard or read something about the facts of the case. Let's start with Mr. Owens. What's the state's position on Mr. Owens?
Your Honor, the state's position is that we can't keep this jury panel. It's busted at this point. The first juror indicated that he had read materials accusing the officer of planting evidence. When we asked him questions as to his impartiality, he hesitated. One point, I believe he said, maybe I don't think so, and then changed his tune a bit. Given that, and also I know during jury selection, there was a few times we talked about there doesn't need to be an equivocal response. It just needs to suggest that they're unable to be impartial and fair during the trial. He also said that the article was titled TPD Officer Planted Evidence. That's extremely concerning for jury purposes. Additionally, the second juror that we heard from who said he viewed the evidence, he stated initially right off the bat that after seeing that evidence, all of his questions were answered that he had from jury selection, meaning he's already formulated an opinion. In this case, I believe he's already stated he has an opinion. When this court asked if he can be fair and impartial, he never actually gave a definitive answer. He instead said that he indicated that he has concerns about the outcome and the impact that it has on the defendant. Based on those 2 reasons, we don't believe that we can have a fair and impartial trial process with 2 individuals who have already seen this materials.
Thank you. Defense, what's your response? Let's start with Mr. Owens.
Certainly. So there's 2, and I'll take them in order. Mr. Owens is less close than the other one. He did not indicate, there's not record evidence that he indicated he can't be fair and impartial. The mistrial is not warranted in every situation where a jury has been exposed to potentially prejudicial news coverage. So the essential question is whether the juror retains the requisite impartiality, whether he can set aside any opinions that he has formed, whether those opinions are fixed or not, and whether he can view the evidence fairly to both sides. There's not a sufficient record that he cannot do so. Next, I'm going to move to the second juror. I actually had the opposite recollection of what he just said. He did say he had an opinion, but he followed up by saying he has questions he wants answered, not that he has no questions. My recollection. That's exactly the role of a jury, to answer some of these questions. As we just discussed during the motion to dismiss, there are questions of fact that should be resolved by the jury. He has questions based on what he saw. There's not sufficient record here to suggest that any of the jurors have gotten rid of the requisite impartiality. One of the factors that the courts addressed that you should consider is that whether or not the potentially prejudicial matter is going to be adduced into evidence as competent evidence. He stated that, I believe he said it wasn't narrated over if he saw the video. It was going to be the same thing. If he just saw the video, it's going to be the same thing that's presented. It's going to be adduced as competent evidence at trial. Finally, there was no mention of him seeing the deposition or anything like that. Even after a finding of harm after an inquiry, or even after finding them harm, like let's say you find they are irreparably harmed, the inquiry does not end there. The court must next determine whether or not a curative instruction can adequately instruct them they should disregard any impression from the publicity and decide the issues and render their verdict. There's also not record evidence suggesting that the jurors cannot disregard any opinions that they form. Forming an opinion is not itself fatal. It's probably a good thing to have an inquiry over, but it's not itself fatal. The issue would be if they cannot disregard, and then further, if the court can't adequately instruct them in a way that would tell them to disregard. And then finally, there's another layer to this as well, in that it is a speedy demand. So the overlap, I think, is kind of an interesting legal issue between the speedy demand and the jury's opinions based on pretrial publicity. The standard for retrial to survive double jeopardy is manifest necessity. It's a very high standard. Standard is referenced in Cohen's v. Elwell. That's the first DCA case, 600 Southern 2nd, 1224. In that case, that case addressed for different grounds. It was for purpose of a missing witness. For a missing witness, strict scrutiny is the standard that's appropriate for deciding whether there's manifest necessity for mistrial for purposes of determining whether retrial would violate double jeopardy. Now, granted, that's a slightly different standard, and there's also a slightly different standard if it's when a jury deadlocks, but that's not what we have here. Because the defendant's constitutional rights are at stake, the case law places the burden on the state to establish that a mistrial over the defendant's objection was based on manifest necessity. So the state has the burden of showing that these jurors can't be impartial, that you can't cure any opinions that they form, that those opinions are fixed, and that a jury instruction would not adequately cover them. They have not done so, in our opinion, not even close. Finally, with manifest necessity, the court has to consider every possible alternative. If the court finds that one, but not the other juror has reached this point, which I don't think is supported by the record, to be fair, or to be clear. But if the court were to find, oh, this juror was worse than this one as far as their opinion, there's the option of switching an alternate. We just have to discuss every possible alternative solution because manifest necessity requires that.
Okay. State, what's your response?
Yes, Your Honor. First, the state would like to point out that this video and the materials that have been published to news media companies, not only locally, but now internationally. I believe I actually saw a news article over in the United Kingdom about this case. The materials that it's based on is not just the body-worn camera footage that was leaked to the press. It was also based on the deposition video of Officer Oliver. I believe that the way that they explained pertaining to the policies and whether or not certain policies existed in those articles and the things that they've been mentioning in the news with narration have been related to that deposition and what she stated during it. That deposition was supposed to be, as we are aware, this court previously ruled Officer unavailable due to her surgery and the fact that she just gave birth to her child. That video was supposed to be played as the deposition testimony at trial. This isn't a situation where they only have information from the body-worn camera. The information that's been exposed to these jurors has also been the deposition information that they were supposed to be playing here today and listening here today. Additionally, I'd like to point out that the video that has been published online has been sliced, it's been altered, there are significant portions of it missing. I believe the actual body-worn camera is almost 40 minutes long and it was reduced down to a 2.5-minute video. Based on that creates a misconception as to what potentially happened, and the jury should have been able to see that in its entirety without having a misconception broadcasted to them before this trial took place. The other thing I wanted to point out, Your Honor, is the defense keeps arguing a manifest necessity. Now, when it comes to this case, I've checked with the Tallahassee Police Department, I checked with the clerks, I checked with our office. We can confirm that none of us released these documents. None of us released these the deposition. We did not release the body-worn camera. I'm not sure who released it, but it wasn't us. But when it comes to the deposition video, I do also want to point out that we talked about this in court. We talked about how big that video was. I believe Ms. Goodfellow mentioned that their office was struggling to get it on a disc. Our office had to have multiple IT people working on it. I'm not sure how the media even got that deposition in the first place. So based on that, we would ask that this is a manifest injustice to the state. If we were to take this to trial with either of the two jurors who have seen it, there is still a cognitive bias, an implicit bias that could be in the back of their heads. And it does not take away from the fact that that could indirectly influence their opinion, even if they're not willing to admit it here today. In fact, one of those jurors admitted that it has already answered his question that we were supposed to resolve at trial. That is a manifest injustice. And that is a manifest injustice that should not have happened before this. It's impeding the judicial process. And if I could just have one moment to confer, Your Honor. Your Honor, there's a few additional points the state wants to make. First, the defense addressed that there was a speedy trial issue. We attempted to select a jury. We attempted to pick a jury. We are ready to go to trial today. So the speedy trial demand has already been satisfied. So that's not an issue in this case. Secondly, I know earlier I said manifest injustice. I want to just correct myself. This is a manifesting necessity, because at this point, with how highly broadcasted this case is across the world, the bell has already been rung. There is no possible way for the state to have a fair and equal and impartial jury at this point in a fair trial process with this media attention. We would need to select an entire new jury to make sure everyone hasn't seen the news for it to be fair and impartial. And that's why it is a manifest necessity, and the state is asking that we select a new jury at a later point.
Wouldn't it arguably be more difficult the longer we wait, the more that this is out in the media, to pick a jury that hasn't seen anything about the case?
Your Honor, it could go either way. It really depends, and I understand your concern. However, with these jurors, the information that's been made available to them, again, like I said, the bell has already been rung. I'm not sure if there's maybe been discussions within the jury room. I'm not sure what they've been told by their friends and family. The point is that the bell has been already rung. It's not possible for us to have a fair trial process at this point with these jurors.
Mr. Henley?
First of all, the deposition was not addressed by any juror, so that was questioned. It is not at issue. It's not whether there's pretrial publicity, it's whether they've seen it. None of them addressed the deposition, so that's a non-issue. We'd ask you to disregard the state's arguments surrounding the deposition. What we have to go on is the record evidence. What have the jurors told us about what they've seen? We are down to 2 jurors even at issue who have seen it at all. It's not could, as state saying could, this could harm, potential, may, might, no. You have to show based on the record that it has, that it will, and that you can't cure it through an instruction. Neither of those problems have been met. And it's not just that it's a misconception, it's uncurable. So I'd ask you to disregard the deposition arguments from the state because it is not at issue. None of them have indicated after thorough questioning from the court, an opportunity question by both sides, that they even saw the deposition. So it's not at issue.
All right, let's take the jurors one by one instead of arguing to strike the whole panel. Juror Owens, what is the state's argument for striking Juror Owens?
Yes, Your Honor. Juror Owens, when he stated that he saw it, he indicated to us that the headline was TPD police officer planted evidence. I asked him several questions following up about how that would influence, and he hesitated, Your Honor. He hesitated as to whether or not that he would be impartial. He hesitated as to whether or not he, the way he answered, Your Honor, indicates that there may be some implicit biases that may not have been expressed with the court. Specifically, his words were, quote, maybe, don't think so, when he was asked. So with that being, within that juror alone, we believe that the headline has rung the bell for him. It's already put the implicit biases into his mind. If we were to keep this juror, that's going to be sitting in the back of his mind the entire time. And the simple reality of this case is that we're looking to the facts. And with a headline as strong as TPD officer planting evidence, that's going to confuse the issues of the case. That's going to mislead the jurors as to what the facts and the evidence were supposed to be for detecting impairment. So we would ask that that juror is not included in the panel.
Okay, thank you. And just response to just Owens, please.
Yes, this juror was directly asked whether he could be fair. He said he believes so. The inquiry's over there. He believes he can be fair and impartial. That is nowhere near the standard needed to excuse under normal circumstances, much less to meet manifest necessity to force a retrial over double jeopardy grounds. It's not even close. He believes he can be fair and impartial.
So I'm not going to dismiss Juror Owens. I admittedly am concerned that he watched a video that is obviously, in my opinion, trying to sway people's opinions, that has a title of TPD officer plant evidence, but when asked directly, he said that he could be fair and impartial. I know that he might have wavered when he was initially asked, but it looked to me like he was just trying to think about it and give an honest answer, so I'm not going to strike Juror Owens.
Yes, Your Honor. Yes, Your Honor. The state understands your ruling. We do have a case that we would just like to place onto the record.
Okay, you can put on the record.
Specifically, the case is Freeman versus State. This is from the Second District Court of Appeals here in Florida. The citation is 50 Southern 3rd, 1163. Specifically, the holding in this case is that the trial court's failure to excuse a juror for cause is manifest error when the juror responds with equivocal or conditional answers, thus raising a reasonable doubt as to whether the juror possesses a requisite state of mind necessary to render an impartial decision.
Thank you. And my ruling is that his last answer was not equivocal.
Understood, Your Honor.
So let's go to Mr. Green. What's the state's argument for Mr. Green?
Your Honor, arguably, Mr. Green has stronger grounds for why he should be excluded from this jury panel. Specifically, when he was asked about seeing the information, he stated yes, he saw it, and specifically that all his questions that he had during jury selection have been answered. He's already formulated an opinion in this case. He responded in the affirmative when he was asked whether or not he had an opinion. He stated that he had already formed an opinion as to what the outcome and the impact it had on the defendant. Keeping this juror on the panel could essentially lead to just juror nullification, which would not be an ability to follow the law based on his feelings and his emotions. And based on the case law that we provided, there is concerns that he is unable to be fair and impartial based on his feelings for the outcome and the impact that it's had.
Thank you. Mr. Henley?
We completely disagree. The way the state could meet this burden would be had they asked follow-up questions about the extent to which that opinion is fixed, whether or not a full showing of the video, because he admitted it's a clip on I forget the channel, but on TV. The clip on the TV is different from the headline, I might add. We don't know, it wasn't presented on the record what the headline that he saw was. So the concerns from the prior juror are not present. Further, the way that the state could do this is if they had asked follow-up questions on whether or not that opinion was fixed, if seeing the full story would change things for him, if he would be biased towards one side, if he could give the state and the defense a fair shake. None of those questions were asked. We have an insufficient record to support excusing this juror.
Your Honor, the state's position is the fact that he has questions answered based on his view of that video is enough grounds for that. I know defense counsel mentioned that there were certain questions not asked, but they didn't pose those questions either, so I don't believe that is grounds for their argument. The state would still state that there is an extreme concern that his impartiality has been affected. Although we don't know what the specific headline was that he read or heard in the news, it doesn't take away from the fact that nearly every single publication in the news has been stating that a TPD officer is accused of planting evidence. And that's the basis of what is being accused in the media. So that's the most likely substantial likelihood of what his understanding of that is.
Brief
I want to
response.
add that is burden shifting. It is their burden. If the defense did not ask these questions, that's the state's problem. They have to develop that record to support striking a juror for cause, and it has to meet, in this scenario, manifest necessity, which is nowhere. That is burden shifting. We do not have to support, or we don't have to build that record in that manner. That is their job.
So is it manifest necessity to dismiss the juror, or is it manifest necessity to cause a mistrial?
They sort of interplay here. And that's what I was saying in my initial argument. So the decision whether to grant a mistrial due to pretrial publicity is within the sound discretion of the trial court. That's the standard. However, there's also a speedy demand here. This is the last day for retrial. So in order to grant a state request for a mistrial.
But they're not asking for mistrial at this point. They're just wanting me to dismiss this juror. We have an alternate that we can plug in. So what's the standard of proof? It's not manifest necessity, correct?
Grant, correct. The manifest necessity is solely for purposes of retrial. That's correct. We still don't believe there's an adequate record. That changes nothing other than that specific argument. We still think it's a vastly inadequate record to support striking this juror. It is their burden, and they have not met that burden.
So I do find that I have reasonable doubt whether Mr. Green can be a fair and impartial juror. So I am going to strike Mr. Green based on his responses that his questions were answered and that he had formed an opinion after seeing the video, which would move Ms. Jones from being an alternate to being on the jury. We don't have a mistrial issue. I mean, I know you asked for one. I'm denying a mistrial based on the pretrial publicity. We have adequate jurors to try the case. So at this point, we're going to move forward.
For the record, the defense objects.
You object to the...
Specifically to the striking of that juror.
Okay.
We do want to proceed. We do not want a mistrial. I'm not objecting to that ruling, just the striking of the juror.
Okay. All right. So let's bring Mr. Green out one more time, and he can bring whatever items he has with him. Mr. Green, I want to thank you again for your service and for being here today. I want to thank you for your honesty in answering our questions. I know that you saw something that was of no, you didn't try and see it. It was inadvertent. You are excused from stage.
Oh, thank you. Let me get my boat. Thank you. Thank you very much. I appreciate it. Yeah.
If you go down, then you want to step these down and for you to walk out.
All right, so it is 9:54. Let's take a 5-minute recess before we proceed with anything else that we need to discuss.
They have another board to try. Let's see if I can find that guy out. We're getting a little pissed. We're trying to resolve that. Are you in house room? Or are you local?
That's the court. Do what? Max, that's not Oh, really?
I'll tell you, man, I got a studio downtown, and I just traded it.
Right.
Audio I just find so like just find it like impossible.
Easy?
No, it just is impossible. And like, you know, I guess this video to me is just like, makes more sense.
Sure.
You know, audio to me is just like this like weird thing.
Right. So the people that run it. I'm glad she said that. It is.
Is the state ready to proceed?
The state's ready for trial.
Defense ready to proceed?
Yes, Your Honor.
Okay. And I believe on my trial order, I gave each side 30 minutes for opening. Does either side think they need more than 30 minutes?
The state doesn't need more than 30 minutes.
Neither does the defense, Your Honor.
Would you like me to give you a 5-minute warning?
Yes, Your Honor.
Yes, Your Honor.
Okay. Any other issues before we bring the
Yes, Your
jurors?
Honor, there was one additional issue that we wanted to address with the court.
Okay.
It's my understanding that based on the recent publicity in this case, originally Officer Oliver's deposition was intended to be played as in lieu of her testimony physically. Based on that, the state presented evidence, including a doctor's note from her doctor indicating that she was unavailable for trial. However, we were able to procure her as a witness, so we will be calling her as a witness today.
Okay. Any issue from the defense?
Your Honor, we need a few minutes to confer. That's a huge change that could have easily been told to us at any point before, the moment before the jury's coming in. If we could have 5-10 minutes, that changes things.
Your Honor, we would just like to clarify as a state, the defense previously, they wanted her present. They were the ones who requested her presence at trial. We were able to procure her according to the rules of Florida criminal procedure. This is something that they could have anticipated based on the rule within itself. Additionally, the only reason this is late disclosure is because of the publicity that was happening. We were originally intending to still play the deposition.
Response, because I mean, you guys did object to her deposition being played and wanted her here in person.
We're not expressing an opinion right now on
Okay.
either way, so I'm not saying I'm reversing anything we've said previously. I just need a moment to confer because that is a huge change that could have easily been communicated at any point before the jury's right about to walk in.
Okay, I'll give you 5 minutes.
Thank you.
No, like, you know the sound that it makes when you get. You do? Okay. Because I heard it. Yeah. Maybe it's, I know you're about,
I figured out a way there.
you just turned the little.
I just turned the volume down. There was another way to do it.
The little side, I think.
Yeah, that's what I'm doing.
The little side.
That's what I do.
Or actually, I don't know that.
I don't know. If I turn the volume up. Oh, yeah.
Yes, I know.
Well, either way, it's not me.
That's fine. That's
I
good.
changed it after the anal.
Yeah, because like,
And it was driving me crazy.
well, we've had like so many. I mean, it's like, you know, crazy.
Back in the record, State v. Riley. Mr. Henley, have you had time to confer?
We think we can get everything done. We will need a moment, probably 10-minute recess for technology after opening, and I think we can get everything done accordingly.
Okay, so you just want to do the openings, take a 10-minute break to get ready for the witness to testify?
That works for us.
Okay.
Your Honor, we also just have one additional issue to address.
Okay.
The state does have one additional piece of evidence that we intended to introduce. It's a certified court document that was filed with the clerks by the defense relating to the defendant's address. We intend to introduce this at trial. However, there is a concern with it. Specifically, it does mention public defender on it, and we want to make sure to have permission by Your Honor to redact those portions on the certified copy.
Okay, so what exactly is the document?
May I approach and give it to you, Your Honor?
Can we see what it is?
This was filed with the courts.
Okay. What date was it filed?
June 27th, 2022.
Mr. Henley or Ms. Goodfellow?
Your Honor, we're trying to get this pulled up.
It looks
Goodfellow,
like
pulling it up now.
It looks like it was stamped on June 27th, but I'm showing it filed on 7/6.
Okay, thank you.
In the court file. And when would the state intend to enter this?
During our case sheet.
Okay.
Sorry, you said 7/7 is the date?
7/6.
Oh, 7/6, thank you.
I don't know if our systems are the same, but it's the 13th docketed item in the case on my system.
Few things. First and foremost, we're obviously asking for Richardson. Later than the last late minute disclosure, so we'd ask that that be conducted. We object on work product grounds. It appears to be an internal document that was inadvertently filed. Our updated client information should be within our own case files. That is not something that we publish. That is not something that is intended to be filed in any case. I'm not sure why or how it was filed in this case. To the extent that it's work product, we would ask that it be excluded. To the extent it's a discovery violation, we would ask that it be excluded. To the extent that it bears any relevancy, it's after the alleged incident. So him changing an address after the incident bears no relevancy to the crime charge, and we're objecting strenuously. This should not come in. It has no bearing on the case, and it is extremely late.
State.
If I could just have a moment, Your Honor.
It's sort of interrelated, but in addition to work product, I'd also object on privilege grounds.
All right, so let's just talk about that for a second. This is a document that's filed in a lot of cases. This is not the first case that I've seen this filed in. So what are your grounds for a client's address being work product or privileged?
It is a communication so that we can get a hold of our clients and communicate with the client. It is not intended to be, that's an even bigger problem if it's happening in a lot of cases. It is not intended to be something that is broadcast. We are communicating with the client about where to reach them and how to reach them.
Madam Clerk, can you see who filed that document? It's an internal name, it's not a name from the public defender's office? All right, State, what's your response?
Yes, Your Honor, a work product, if it's work product and it's intended to be confidential, it shouldn't be given to the clerks for filing in the first place. The fact that this was placed in court records, defense has had this since day one, since charges were brought. They had every opportunity to review the entire court record. They would have had knowledge and notice of this document being filed if they had done their diligence in looking through everything. I'm not sure what exactly happened and maybe why it was filed. However, when it comes to this document, it does not take away from the fact that it's public record. Additionally, it's the exact same address that the notice of his suspension of driver's license was sent to. It goes to knowledge, it goes to that. Additionally, the defense should have known that.
Mr. Adams.
I find it strange to cry late disclosure when they're disclosing this so that we should have known. They are responsible for getting us discovery within 15 days of the filing of the information, not 15 seconds before the jury walks in.
But this is your document.
It was inadvertently filed. This should not have been filed. The error on filing it doesn't change the unjustness of introducing it.
You're arguing two different things. You're saying you didn't know about this document, but this is your document.
I'm saying the argument that we knew about it is misplaced when it is disclosed so late. I'm not saying we didn't know about it. I didn't know about it, but the point is that it's misplaced, right? It's a misplaced argument. to say that we didn't know about it when they should be disclosing things timely. This is the fourth late disclosure since jury selection. At what point can we not rule this is willful? This is the third today.
So if the state intends to introduce a document that you created, they have to disclose it to you.
If they should disclose all the things they're intending to use. Yes. Under 3.220 of the Florida Rules of Criminal Procedure, specifically 3220 1B 1A.
Any additional arguments, State?
Your Honor, I only came across this document yesterday afternoon. It's not something that I was originally intending to go across during trial. As you're aware, this was supposed to be a simple DUI trial initially, and it turned into a national broadcast publicity issue. So it required thorough review of the court file, and as I was reviewing the court file yesterday, that's when I came across it. Considering that this was filed by the defense, this was something that was produced by the defense, they absolutely had noticed that it existed. It's not something that, like I mentioned earlier, it's not something that they wouldn't have known about. And that's the main element for Richardson hearing, something that they did not have notice of. And if I could just have a moment, Your Honor. Additionally, Your Honor, my concern is that there's arguments about late disclosure and these documents not only just being given to them. However, there's been late disclosure from the defense in this case too. There's been late filing of motions that gave the state next to no time to prepare for the hearing. Considering that as well, all of this is in response to their actions in yesterday with these motions as well.
Judge, they're admitting they've done this late disclosure on purpose as a response to us filing a motion to dismiss. That is further evidence that you should declare that this is willful and our request is that you throw the entire case out for Richardson. I think a reasonable alternative is to keep at the very least this privileged documents inadvertently filed, late disclosed out.
I'm going to reserve ruling, let both sides do some research. I'm going to do some research too. I want to see some authority why you think that an address form is privileged that is filed in the court file and is part of the court record.
Understood.
Okay. All right. Do you have one more issue, State?
No, Your Honor, the state's ready for opening statements.
Your Honor, we're waiting for the rule of sequestration.
Okay. Are there any witnesses in the courtroom that are going to be called today?
No, Your Honor. However, all of our witnesses are currently upstairs. We do believe that they will follow by this rule. Additionally, I will have our investigator instruct them on the rule of sequestration.
Defense.
Judge, given the allegations in this case, I'm not comfortable with trusting that they will abide by a rule they have not been instructed on. I'll leave it at that.
Your Honor.
If you could please have them come down, I need to know that they have been instructed on the law, not that you think that they have or they can follow it, so I will instruct
Yes,
them
Your
on
Honor,
it.
there is one witness who's not quite here yet at this point, Officer Gary Roy. He lives 45 minutes away. We know that he was going to be a rebuttal witness if he's not currently present.
Just keep him separated from the rest of the officers when he gets here, and I'll instruct him on the
Yes,
rule
Your
when
Honor.
he does. Officers, if you could just come on up and stand in front of the desks for me. I just need to make sure that you understand the rule of sequestration. Ladies and gentlemen are witnesses in this case, a rule of procedure has been invoked, requiring your exclusion from the courtroom during the taking of the testimony in the case other than your own. Therefore, you are required to remain out of the courtroom during such time and except when you yourself are required to appear and testify. While you are waiting to be called to testify or after you have done so, do not discuss this case or your testimony among yourselves or with any other person. You may, however, discuss your testimony with the counsel or party or the side which caused you to appear here as a witness or their designated representatives. Do you all understand this rule? Okay, thank you. You may now retire.
Judge, I just want to bring to the court's attention on March 31st, 2024, the state indicated they would not be calling, or rather they did not issue a subpoena for Sergeant Smith, indicating that they did not intend to call. We want a brief recess prior to this witness as well, so we can have time to prepare for another unexpected witness.
Was the witness listed on
It
initial?
was listed, yes.
Okay.
Your Honor.
Denied.
The state has no responses, or no.
It's denied.
Okay, thank you, Your Honor.
Judge, sorry, before we begin, I was asking defense counsel, because I cannot recall his argument, but whether or not he was simply rejecting under Richardson with regards to the documents within the court file, or whether he was actually requesting a hearing, because I think there's a difference if he's requesting a hearing. I believe the case law says the court has something.
The court indicated that it would like to reserve, and I assume we'll be conducting.
Yeah, we will have a hearing after you guys have had a chance to do a little bit more research.
Thank you. Thank you.
Because I want to address all of the issues pertaining to that
And
piece
just
of
for
evidence.
clarity's sake, it is both. We're both objecting as well as requesting a hearing. They're part and parcel.
Okay. Any other matters from the state?
No matters, Your Honor.
Defense?
No, Your Honor.
Okay, let's bring in the jurors.
All rise, jury entering the courtroom.
You may be seated. We are back on the record. State v. Riley, case number 23CT845. Is the state ready to proceed?
Yes, Your Honor.
Defense ready to proceed?
Yes, Your Honor.
Thank you. Jury is present in the courtroom. Defendant is present at counsel table. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Calvin Riley. This is a criminal case. Mr. Riley is charged with driving under the influence and driving while license suspended or revoked. The definitions of driving under the influence and driving while license suspended or revoked will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as evidence or as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Mr. Riley in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have an opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, the alternate juror will be released, and you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, and other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure that your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in case of an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. This case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, or any electronic device, or any other means at all, to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any places discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family member make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom during breaks. During recesses, the bailiff will take possession of your notes and will return them to you when you reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. State, do you wish to make an opening statement?
Yes, Your Honor.
You may proceed.
May I have a moment to set up the well? May I proceed? May it please the court, defense, members of the jury. It was 2 a.m. and he was driving with no headlights on. It was 2 a.m. and he admitted to drinking alcohol. And he admitted to being at a local bar. Good morning, members of the jury. My name is Emma Hershey, and I'm a certified legal intern with the State Attorney's Office here in Florida. We represent the people of Leon County. And we're here today because the defendant in this case is charged with two things. First, he's charged with driving under the influence. And second, he is charged with driving with a suspended or revoked license. These are two things that we talked about during jury selection, so I just want to briefly go over what to expect for the state to prove in this trial. So first, driving under the influence. There's two things that the state must prove. First, that the defendant drove or he was in actual physical control of a vehicle. Now, actual physical control of a vehicle, that doesn't mean that you necessarily have to be driving down the road when law enforcement encounters you. All it means is that you have to operate a vehicle, be capable of operating a vehicle. Now, we expect in today's case that you're going to see that this element will be easily satisfied. You're going to see in body-worn camera footage that the defendant was driving his vehicle. So we expect that we're going to establish that element. The second element that we must prove to you today is that while driving or in actual physical control of a vehicle, the defendant was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. This is another thing that we talked about during jury selection. What signs of impairment are. See, you're going to learn throughout today's trial that impairment isn't necessarily falling on the floor drunk or tipping over, struggling to walk. It can be something as simple as your vision is affected when I take my glasses off. It can be something as simple as not being able to follow instructions, struggling to find documents. It can be something as simple as slurring your words. But members of the jury, here's another sign that we expect for you to see in this trial. Anger and aggression and an outburst of emotion. That's another thing to look for as we proceed. The second charge in today's case is that the defendant was driving with a suspended or revoked license. Now, this charge has three different elements that we have to prove to you here today. The first element is that the defendant drove a motor vehicle upon a highway in this state. Now, that applies to any roadway really here in Florida. So if you hear that the defendant was driving down we expect that you'll hear that the defendant was driving down Monroe Street when this incident occurred, that he was driving a vehicle. That brings us to our second element. Number two, that at the time he was operating his vehicle, his license was suspended. You're going to learn in today's trial that the Department of Highway Safety and Motor Vehicles issued a notice of suspension to the defendant. Not once, not twice, but 3 times before he was stopped on May 7th of 2023. They sent this notice to his P.O. box that he specifically requested them to send his mail to. So we expect that we're going to establish that element here today. Third, we have to prove that at the time the defendant knew that his license was suspended. And this kind of plays with element 2. We expect that you're going to learn that because the defendant had access to his P.O. box, he had the ability to know of it, and he had notice of it because he was sent it 3 times in the mail. 3 times. Now, the judge is going to instruct you that anything I say during opening statements, and if the defense chooses to give an opening statement, that anything they say should not be considered evidence. What we're doing in opening statements, this is a general guideline, a roadmap as to what you can expect in today's trial. Kind of like painting a picture. So that's what I want to do for you. It's May 7th, 2023. 2 Tallahassee Police Department officers are on the side of the road on North Monroe Street, responding to a completely different traffic stop. And as they're responding to this different traffic stop, they notice a vehicle traveling at a high speed, whipping down the street over the speed limit. And at first glance, it might sound like it might just be a speeding ticket, but it wasn't just an ordinary, usual speeding incident. This wasn't an ordinary traffic stop. Because the issue is that the vehicle was traveling with no headlights on. Like I said, this happened at 2 a.m. in the morning with no headlights on North Monroe Street, which is a busy road. So seeing that this car is driving down the road with no headlights over the speed limit, one of those officers, her name's Officer Kirsten Oliver. You're going to hear from her today, and she's going to get on the stand, she's going to testify about her observations. She's going to tell us about how she hopped into her patrol vehicle and decided to pursue the vehicle, how she had to speed up to try to catch up with it. And as soon as she's finally close enough to finally put her headlights on and her emergency lights, you're going to learn about the defendant's driving pattern. You're going to learn that he was swerving. And when he was swerving, he almost swerved into another vehicle in the right-hand lane. That's finally when he stopped. You're going to learn that, yes, he put his blinker on. He put his blinker on. But did he get over to the side of the road? No. You're going to learn that he didn't get over to the right-hand shoulder. He didn't get over into a safe area to park. You're going to learn that he stayed in the middle of the road. In fact, his tire wasn't completely over into his lane. Close enough that another passing by car could have potentially sideswiped him. Now, members of the jury, you're going to learn from Kirsten Oliver that at that point she got out of her vehicle to go speak with the occupant of it. When she approached the vehicle, she noticed one individual alone inside of it, the defendant. When he rolls down his window, I want you to pay attention to the body-worn camera and look for the signs of impairment. You're going to hear about how law enforcement officers are trained to look for signs of impairment and what specific things can point to alcohol impairment. Number one, the defendant's words. How did he react? Why do you slow me down? That's his reaction. Number two, he's got glossy eyes, a sign consistent with DUI, or driving under the influence. Number three, he's slow, he's sluggish, he's asked to get his driver's license, he's asked to get his registration. You're going to learn he could never find it. You're going to see the body-worn camera footage of him struggling and flipping through papers and documents and never be able to give it to law enforcement. And during that entire process, you're going to hear his words. You're going to hear how he slurred his words. And at that point, Officer Oliver takes a pause. See, what I want you to pay attention to during Officer Oliver's testimony is that she was a relatively new officer, only with the Tallahassee Police Department for about 2 years. And when you're new to something like this, you might not be the most comfortable conducting an investigation on your own. So members of the jury, Officer Oliver is going to tell us about how she hadn't done a lot of investigations of this sort at that point. So she decided to go back to her police car and call a friend. Not just a friend, but her coworker who had experience with driving under the influence cases, with investigations. And that second officer, her name is Officer Margaret Muth. You'll learn that Officer Margaret Muth actually worked over in Oregon for a while, and she handled DUI cases there before she came to TPD. And you'll also learn that the sole intent of why Officer Muth came to the scene is to help detect signs of impairment, and nothing more. So now let's talk about what happened when Officer Muth gets to the scene. You're going to learn that Officer Muth came to the scene, and Officer Oliver indicated, I'm not sure. There might be a smell, there might not. She's going to say, hey, can you help me? Can you help me do the investigation so I can watch, so I can learn from you? Miss Officer Muth says, yeah, sure, I'll do that. Decides to walk away from Officer Oliver, goes to approach the defendant on her own. You're going to learn that she makes her own assessment as to whether or not the defendant is impaired. She'll say the same things. She noticed glossy eyes. If you notice, slurred speech. More importantly, she's going to tell us something that the defendant didn't tell Officer Oliver. And this is what I
Burden shifting.
Sustained.
You're going to learn that the defendant told Officer Muth two things. First, that he was drinking alcohol. I believe he said that he had 2 beers that night. Number 2, you're going to learn that the defendant told her where he was coming from that night. So, members of the jury, it's as simple as the defendant was at Pockett's Bar and Grill earlier that night. He spent the night there drinking alcohol, and then he decided to get in his car and leave, drive home. At that point, the officers go back. You're going to learn that there was more than just a DUI investigation at that point. That they also decided to pull up their internal program, run a driver's license check on them, just like any other traffic stop that occurs. And when they did that, they noticed that the defendant's license was listed as suspended. That suspension was caused by the lack of insurance he had for his vehicle. His car was not insured, as the laws here in Florida mandate. So when Officer Oliver and Officer Muth see this, you're going to learn that they go and place him under arrest. And that's where the next part starts. You're going to learn that those are the signs of impairment. That's when he's arrested. And then there's an additional investigation. So let's talk about that additional investigation. After the defendant is placed into handcuffs, brought over to the patrol vehicle, there's 2 things that happen. Number 1, a search of his vehicle. And number 2, something called implied consent. So I'm going to take those one by one. The search of the vehicle. The search of the vehicle happened after the defendant was placed under arrest, after the signs of impairment had already been established. When the search of the vehicle occurred, you're going to see every part of the video, every part of the body-worn camera, and exactly what the officers did. You're going to learn that both officers went from one side of the car to see what they could find. And when Officer Oliver was searching, she noticed on the driver's side that there was an alcohol bottle in a pocket. When she noticed this at first, she left it in the car. She didn't do anything with it initially. But you're going to learn that later along in the investigation, when Officer Muth was at a completely different part of the scene, talking with the defendant, Officer Oliver made a mistake. I'm going to be honest, she made a mistake. Thinking that TPD policy, the Tallahassee Police Department policy, was that you're supposed to dispose of alcohol, she decided to do that. And let's be clear, you're going to learn in this trial that there is a policy that specifies that. And she's a new officer, so that's what she's trying to do. She's trying to do her best to stay and stick to protocol. So seeing this bottle, she goes to open it, to dump it out, not realizing at the time that it was sealed. She's going to tell you that she didn't realize that and that she made a mistake. Now, after this happens, she dumps it out and puts it back in the vehicle. And that's all that happened. They didn't take it into evidence. It's not something that they necessarily thought was the most crucial piece. The signs of impairment were the biggest piece of evidence in this case. And that's all that happened. So I want to talk about the second part of their investigation that I mentioned, the implied consent. Another thing that we briefly touched on here during jury selection. See, in the state of Florida, when we get a driver's license, or if we agree or even operate on the roadways here, we automatically consent to what's called a breath test. And that's basically where, when law enforcement asks for a lawful sample of your breath, you're supposed to agree to it. At first, that might not sound like a big deal, like, hey, I might want to refuse it, but you're going to learn that it is a big deal. Because in Florida, if you refuse a breath sample of this sort, you automatically lose your driving privileges for an entire year. No driving to work, no going to the movies, no going to the mall.
Your objection has collateral consequences.
Overruled.
as well as in the statement of law.
Just move on from it.
When law enforcement informs the defendant of these consequences of the implied consent, they read him a form telling him that he'll lose his driving license privileges for an entire year. What does he do? He screams, he shouts, he talks over them. You're going to learn today that the defendant's behavior was so belligerent in that moment that they had to call a third officer to the scene.
Objection inflammatory.
Overruled.
When that third officer, who you'll hear from here today, his name is Sergeant Brian Smith, he's going to tell us about what the defendant said in response to the breath test. Because you'll learn that he wasn't asked once, he was asked multiple times. In fact, when Sergeant Smith asked him, hey, if this is just a big misunderstanding, why not just take the breath test? You're going to learn that he still refused.
Objection burden shifting.
Overruled.
Members of the jury, what I'm asking from you in this case is to stick to the facts and look to the facts of the case. The facts will guide you throughout this trial and throughout your deliberations. You are sworn to uphold the law and the law alone. The facts are simple. He was driving. He admitted to drinking alcohol. He admitted to being at a bar. Notice was sent to him 3 months in a row saying your license is suspended because you don't have insurance. And he still chose to drive despite knowing his license was suspended. He still chose to drive because even though he knew he had drank alcohol. The facts are simple. At the end of today's trial, you're going to hear from all the witnesses who are necessary. You're going to have the opportunity to review evidence and video footage. And at that point, we're confident that you're going to see the truth, that the state has met its burden, that we've proved this case to you beyond a reasonable doubt. Not a mere speculative doubt or forced or imaginary doubt, a reasonable doubt. You will see the truth, and the truth is that the defendant is guilty.
Defense, do you wish to make an opening statement?
Yes, Your Honor. Calvin Riley is innocent. This case involves an officer planting evidence. I'm not going to sugarcoat it. What you are going to see from the officer is shocking. It is egregious. It is outrageous. It is not an innocent mistake. There is literally an officer on camera making evidence where none existed. And I expect all of you will get to see with your own eyes. Officer Kirsten Oliver of the Tallahassee Police Department stopped Mr. Riley for his headlights being out. She claims she smells marijuana. You will hear Mr. Riley protest. He does not smoke marijuana. The claim that she smells marijuana is what lets her search the vehicle. Officers removed Mr. Riley from his car, put him in a patrol car, and then search his vehicle. They of course find no marijuana, not one bit. And that's for the simple reason that Mr. Riley does not smoke marijuana. However, it is what she does next that is truly shocking. Officer Oliver reaches in Calvin Riley's vehicle, grabbed a full, sealed, unopened bottle of liquor, cracked it open. You will actually hear the plastic seal break. It is a distinct sound. You're going to see it from the angle of her own body camera. She was too brazen to even bother turning it off. She then pours out some, but not all of the liquid, puts the cap back on, and then tosses the bottle back into his vehicle. She then lies and tells the officers that she found an open bottle. Mr. Riley was pulled over on his way home. I expect you will hear that while he was driving home, Officer Kirsten Oliver pulled him over for not having his headlights on. You will see how a simple traffic stop escalated based on what I expect you will hear Officer Oliver herself testify were actually just assumptions. You will hear from officers that Mr. Riley smelled like marijuana, but that's not even possible because, as you will hear, Mr. Riley does not smoke marijuana, nor lets anyone smoke marijuana in his car. I expect that you will hear that no marijuana was found in the vehicle when officers searched it. Just a phantom marijuana smell. Mr. Riley has been charged with driving under the influence and driving while license suspended or revoked. You will learn that officers claim to initially have arrested Mr. Riley for driving while license suspended or revoked and not DUI because they didn't have probable cause for DUI when they arrested him. The judge will instruct you that the state must prove Mr. Riley had knowledge that his license was suspended when he was driving. You will hear Officer Oliver assume Mr. Riley knew without any actual proof. This is important because they are required to prove beyond a reasonable doubt that he knew his license was suspended. The state will rely on the officer's ability to smell. However, you will not see evidence that they found anything consistent with that smell. Judge Jones will instruct you that reasonable doubt comes from three places: the evidence itself, conflicts in the evidence, and a lack of evidence. Pay close attention to the evidence. Not only the evidence you see and hear today, but also what you don't see and hear today. When at the close of evidence you have reasonable doubts as to what actually occurred, when the government has not expelled all reasonable explanations from your mind, justice requires that your verdict be not guilty. The evidence will show the police created a crime where none existed.
Thank you, Ms. Goodfellow. So, can we go sidebar for 1 second?
Yes, Your Honor.
All right, so ladies and gentlemen, we've decided we're going to take an early lunch break, and I'm going to give you all a little bit of time because there are some other things that we need to discuss. So you will have until 1 o'clock for lunch. It is just a little after 11 now. That'll help you beat the lunch rush. And I want to stress to please avoid looking at or reading anything about this case. If you hear anyone in the courthouse or out in downtown Tallahassee talking about it, please turn and go the other way. And again, if someone tries to talk to you, tell them that you are on the case. Make sure that your stickers are visible to everyone. And if they persist to try and talk to you about it, leave them and please come back and let the bailiff know that someone is trying to speak to you about the case, okay? Do you have any questions? All right, so Madam Clerk, where do you want them to come back? Okay, please come back where the clerk picked you up this morning downstairs at 1 o'clock. Please leave your notes on your chairs. You may be seated. All right, so we will return at 12:30 to discuss any outstanding matters, any issues before we take a break for lunch.
None from the state, Your Honor.
The defense?
None from defense.
Okay, we'll be in recess.
Thank you.
I'm still sending out a signal. I'm not recording.
All right, we're back on the record. State v. Riley, defendant is present at council table. Ms. Goodfellow, are you ready to proceed on the discovery issue?
Just one moment. Your Honor, which one do you want to proceed on first?
So we have the issue of the address change form. What was the other issue?
Is it Sergeant Smith?
Judge, one moment, I'm going through some case law in preparation. We also have something we can do in the interim as far as Officer Roy is here.
Okay.
Yes, Your Honor. The state was hoping to invoke a rule of sequestration for him.
Okay, Officer Roy, if you could just come forward, please.
Yes, sir.
That's fine right there. So Officer Roy, you are a witness in this case, and there is a rule of procedure that has been invoked requiring your exclusion from the courtroom during the taking of the testimony in the case other than your own. Therefore, you are required to remain out of the courtroom during such time and except when you yourself are required to appear and testify. While you are waiting to be called to testify, or after you have done so, do not discuss this case or your testimony among yourselves or with any other person. You may, however, discuss your testimony with the counsel or party for the side which caused you to appear here as a witness or their designated representative. Do you understand?
Yes, sir, I do.
All right, sir. You may retire.
Thank you, sir.
All right, Mr. Henley, you ready to proceed?
Just one moment, if I think so.
Yes, you may.
Tompkins.
These are civil cases.
All right, Mr. Henley, you may proceed with your argument.
Would you like me to address the Richardson aspect first or the privilege?
Let's go with privilege first.
Okay. The documents here, or the document really, though inadvertently filed, is nonetheless privileged and should be excluded both pursuant to Richardson as well as on the grounds of privilege. The case law that we have cited, we believe stands for that proposition. Granted, civil cases, however, the privilege aspect is nonetheless the same.
That's the extent of your argument?
At this time, yes.
Okay, state response.
Judge, if I could just be given a little bit of time to review the cases since we just did receive them. I do have cases coming down that the state has printed copies for the court and defense as well. But before I respond, I'd just like to have a moment to just review the three cases that were provided.
Okay.
Thank you. Your Honor, I'm ready.
Okay, go. You may proceed.
Judge, I think looking at these two cases, they are obviously not analogous to the situation at hand. If you look at the first case, Mercado v. Parent, 421 7 2nd 740, the issue is whether or not the court could order a lawyer who is representing a defendant in a civil action to divulge the client's address, which is a completely different situation than we have here. We are not asking the court to order the defense to divulge anything. The other case that was cited to, which was the Mullins versus Tompkins case, 15 Southern 3rd 798, again, it is a case where the trial court, where the DCA found that the trial court could not order the the dentist, in that case, to disclose the documents based solely on the fact that the dentist had inadvertently given the documents to her expert witness. In both of these issues, Judge, the court is being asked to order a party to divulge certain information, whether or not it was intended to be given out or inadvertently given out. We are not doing that in this case. We are basically seeking to use the documents that counsel has filed, and apparently, and I believe the court even mentioned the fact that when counsel brought up this argument in the first place, the court had even stated that it has seen the defense file these documents in other cases. So I don't believe the court should look highly upon the argument that this was inadvertently filed. If it's a document that's filed to inform the clerk of the change of address, then it's a form that they normally file, and in doing so, they did so to their detriment. But I don't think any of these cases, and I do not believe that the RLR v. State case 116 Southern 3rd 570 would say anything different. This is not a case where the state is asking the court to order anyone to divulge anything. The information has already been divulged. It is in the realm of public record. And for that reason, the state should be allowed to use it.
Okay, response.
Yes, Judge. So looking first at Mercado, that case supports, on page 741, for the record, 421 Southern 2nd 740, as a general rule, an address given confidentially by a client to an attorney while consulting in a professional capacity is a privileged communication. That is squarely on point. So the question becomes whether he gave informed consent to waive that confidentiality. What we have told you in letting the court know and representing that that is filed inadvertently is that he is not given informed consent to do so. It is a privileged matter as is stated in Mercado. RLR v. State, I want to direct the court's attention to page 572, and for the record, that is 116 Southern 3rd 570. In that case, involves the criminal law system. It's a juvenile case. The issue presented in that petition is whether the court may order the attorneys to disclose a minor client's location. Now, the state's saying, oh, that's about the court forcing it. That's true, but it's also about why the court cannot force it. And that's because it's confidential. It's a confidential communication. That privilege has not been waived. Finally, I think the most important one is probably Mullins v. Tompkins. It's 15 Southern 3rd, 798. That one lays out the principle that a party does not automatically waive privilege simply by furnishing protected or privileged material to the party's own expert. The rules of ethical conduct actually have provisions for this. When something is sent over accidentally, as soon as the receiving party realizes that is a confidential communication, probably wasn't meant to be sent there, to stop, inform the other party. The rules contemplate this. The case law states this. It is not something that the state should have access to. It is not something that should have been filed. The very fact that it was inadvertently filed does not change the analysis. It is still subject to attorney-client privilege. Allowing the state to use these privilege matters would be injustice.
So are you arguing that it was inadvertently filed or that it was inadvertently given to the clerk's office?
I don't know the circumstances surrounding how it came to be. The clerk was unable to even see the filer. So I don't have any, there's not record evidence that says it was handed or versus filed. That distinction I'm unaware.
Okay. And so I'm stating for the record that I have seen this in dozens of cases. I regularly use this and announce it on the record in front of the public defender's office when I am looking to issue capiases for failure to appear, that an updated address has been filed by the public defender's office. It is the same address where the notice was sent to, and therefore I'm issuing the capias. So is your argument here today that every time that the public defender's office has filed this, it has either been inadvertently or that you are knowingly filing information that is protected with the clerk's office in violation of attorney-client privilege?
Judge, I'm obviously not arguing that we are knowingly violating any rule of the Florida bar. And I don't think that dichotomy I don't think that fully represents what we're arguing. The argument is that it is inadvertently filed. That alone does not.
How do you know it was inadvertent? Did you inadvertently file it? Did Ms. Goodfellow, do you know who inadvertently filed it?
I've already stated that we've not.
So how do you know it was inadvertently filed?
Because it should not have been filed.
So every time it's filed, it should not have been filed?
We should not file absent a confidential information, absent a waiver by the client. So if there's a signature at the bottom or something like that indicating the client's assent to this, that's different. So that plus the late nature of it is the other half of this that we still have to get to. But it is protected. It should not have been filed, period. I don't know the circumstances surrounding who filed it, how it was filed. I know that it should not be. And it should not be used for that reason.
State.
Yes, Your Honor. Just to address a couple things counsel said. With regards to the reliance on Mullins, again, this was something that the court was ordering to a party to disclose because it had been provided to an expert. If that was the situation in this case, I guess there wouldn't be a problem. The problem here is, and counsel I believe stated this in his argument to the court, was that he does not know the circumstances that led to the filing of this case. I don't know how counsel can make any further representations about whether it was filed inadvertently. He seems to be taking the position now that every time this document is filed, it is done without the knowledge of their clients, which brings up a whole other can of worms. And the problem is, how can he say anything about how it was filed, who it was filed by, if he knows none of those facts? The fact is, Judge, this was filed back in July 6, 2023. And one of the things that counsel talked about that Mullins stands for is, as soon as a party realizes that this has been filed, they need to notify the other side. Is counsel really saying this is the first time in 7 months that they have realized that this has been filed, which brings up a lot of other questions about, does he know what is going on in that office and what has been going on with this particular case? And I would submit, Judge, that he does not. And I would say that there is no evidence before the court other than counsel's representation for which he admitted he knows no circumstances for, that this was inadvertently filed. It was filed. It's in public record that anybody can access, anybody has the ability to obtain, and it has been so for 7 months. For them to say that it is somehow now protected is I think, very disingenuous.
Did you have case law that you wanted to present? You said that you was bringing it down.
Judge, I do have case law. It doesn't go necessarily to this specific issue,
okay,
but I will give counsel a couple cases. And just for the record, Judge, I am handing counsel on the court State v. Miller, 672 Southern 2nd, 855 out of the 5th DCA, and State v. Wright, WRIGHT, 389 Southern 2nd, 289 out of the 3rd District.
all right, thank you. All right, so as to the first issue of whether this is either privileged and or work product, I find that it is not. I find the defense's arguments disingenuous because filing this by the public defender's office is common practice in criminal cases, so I do not find that it is privileged.
I'm going to object to the court's characterization as disingenuous as a departure from the role of a neutral arbiter.
Your objection is noticed.
Thank you.
All right, so let's go to the issue of whether it's a discovery violation. What's your arguments, Mr. Henley?
I beg your pardon, I didn't hear the...
What's the arguments as to the fact that this was untimely discovered?
Yes, this is the fourth late disclosure just today, fifth since jury selection. It is at the point where I think the court should analyze it both individually as well as cumulatively. We are not to have trial by ambush, and that's exactly what's been happening today. We have had, it's really not a joke for us, Judge.
I'm just wondering how you're ambushed with information that you provided to the clerk's office and now they're wanting to introduce as evidence.
There's not record evidence how it went to the clerk's office. So we are ambushed when there are a number of things that are sent late, right before trial, right before the jury.
This
and
is
we
something...
are also ambushed because it's clearly, in our view, confidential material that should not be provided, should not be seen by the jury. That's how we're prejudiced by this. It's cumulative at this point.
Okay. State.
Judge, I've provided the court and counsel with two cases, State v. Wright and State v. Miller. State v. Wright discusses the demand for a speedy trial issue, and my understanding is the demand for speedy was made in this case on February 16th, 2024. When that occurs, once that motion is filed, it is up to the court to determine and have a hearing to ascertain whether or not the accused has a bona fide desire to obtain a speedy trial, and determine whether or not the accused or his attorney has, quote, diligently investigated his case and that he is prepared for trial. And that is State v. Wright, 389 Southern 2nd, 289. The court goes on to say that if those prerequisites of the filing of the demand are not met, then the demand for speedy trial shall be stricken as being null and void. That was not done in this case. Obviously, the court at some prior date had found that they investigated and were ready for trial with whatever information they had at the time. It is up to the defense to make any further objections later on, but the state still has an ongoing obligation to turn over discovery as it obtains it. Now, with regards to State v. Miller, 672 Southern 2nd, 855, the court goes and does an analysis between the speedy trial rules and the discovery rules, and the court finds that they are entirely separate. They are intended to serve two distinct purposes. The speedy trial rule merely limits the time in which the state may bring a defendant to trial. It does not provide or require discovery. Since a criminal defendant has no constitutional right to discover the state's case prior to trial, he or she must rely on the provisions of the discovery rule if discovery is desired, but that rule, as do most, has two edges. If one invokes the beneficial aspects of the rule, they must be prepared to face the provisions of the rule favoring the other party. And in this case, in Miller specifically, unless the court shortened the period, in that respective case, unless it shortened the period for the response for discovery, the defendant would have taken the rules of discovery into consideration, deciding whether or not to force a speedy trial. Here, Judge, there have been at least, the case was filed in May 8th, 2023, and the demand for speeding not made until 11 months later, February 16th, 2024. At that point, the defense has indicated they have investigated the case, they are ready for trial. Now, I'd also point out, Judge, that counsel talks a lot about the issues that have come up and the late filing of discovery by the state. Well, he said it correctly. There were 5 things that were filed within the last few days. The reason for that was what happened in the case, the whole media storm of the case. And that caused my trial partner to go back and look for other things in the clerk system. And in doing so, happened to come across an entry in the clerk system that said, notice of change of address. And that was filed, Judge, July 6, 2023. Now, in no other situation would a prosecutor go back and look at filings for a change of address for a DWS case, because it wouldn't really amount to anything necessarily. You wouldn't expect to find any documentation that you might want to use that would corroborate the particular elements that the state has to prove. In this case, it just so happened to pay off. And the state should not be hindered in the presentation of its case in presenting this information simply because it was doing its due diligence in responding to motions from the defense. And I would also point out that this was filed by the defense, and they should know what they filed in the case. And I think they cannot go back and now say, this is an issue. We did not know about this. I would say in terms of the prongs of Richardson, whether it was willful or, whether or not it was, the disclosure was willful or not, I would say it's not. It was inadvertent. Had we not had the pleadings that were filed from the defense, we would not have gone to such extremes in looking at the clerk system, in trying to respond to their motions to dismiss. As to whether or not it is substantial or trivial, I think that all depends on how you look at it. Obviously, from the state side, I don't think it is substantial. It is trivial. From the defense's side, they would take the opposite position. And I think that that's a toss-up. But when it comes to the third prong, whether or not this affects the defendant's presentation of their case, I would say that that fails. Because this is, you cannot at the 9th hour sit there and say this affects the presentation of my case when we have known about this since July of last year. And for that reason, Judge, I would ask you to find that there is no discovery violation, there is no Richardson violation.
Mr. Henley?
Yes, Judge. The state pointed to a bona fide desire for trial in 5 days, which is not at issue here, but I feel compelled to respond. We did have a bona fide desire for trial in 5 days. We still do. They are the ones who have asked to mistry this case from the morning. And then further, that does not change the fact that we were ambushed after jury selection. After jury selection, we get 5 new late disclosures. One of them, granted, the knowledge of, right, or presumed knowledge of, is filing, but that one we contend is confidential, all right? I understand the court's ruling on that, but that's the reason that one should be kept out. They, in saying that this is in response to a motion to dismiss, that strains credibility, strains the confines of logic. They're admitting they didn't carefully review prior to trial. Though they do have a continuing obligation, that does not relieve them from consequences for violating their duty. They have 15 days after the filing of information to get us discovered, provided there's a notice of discovery from the defense side. A lot of this stuff could have happened significantly sooner, and I think the court should make inquiry as to when each item was received, with the exception of the one that's docketed, and when they had it, and then when it was sent. I think that's important to establish the timeline. I think it's important for a full Richardson hearing. And we're objecting to the constant, or 5 instances thus far of late disclosures. Thank you.
All right. So let's address this issue, and then we'll go back, since you're asking me to mistry the case or dismiss it or whatever for the 5 violations that you're asking. So I don't find that there's a discovery violation. This is something that was in the court file and apparent to both parties if they looked at the court file. It was filed by your office, and whether you're arguing today whether it was inadvertent or not, I'm telling you that it is common practice for your office to file this with the clerk's office. For the sake of creating an appellate record, I am going to have a Richardson hearing. I do find it, if there was a violation, it was inadvertent, it is trivial, and there is no prejudice to the defendant by being confronted with a document that he created. So let's go to your arguments about the cumulative effect of the 5, which I've, on all of them, found that there is no prejudice to the defense. But for the sake of creating a good record, I want you to have the opportunity to argue what each of them were and why you think that the cumulative effect requires the dismissal of the charges.
One moment, Judge. One. Thank you, Judge. So the 5 late disclosures. Officer Roy. Officer Roy's late disclosure. Now, the prejudice of that one likely would depend on whether or not he's actually called and the nature of that. So we'd have to finalize that as to the cumulative effect if and when he's called. Right?
And I believe they said they were only going to call him in rebuttal. Is that correct?
Yes. Okay. The certified judgment and sentences that were sent this morning. Number 2. Number 3, Officer Oliver testifying in court despite being repeatedly told, in fact, having a doctor's note to the extent saying that she was unavailable.
Now, you didn't object to that, so now you're objecting to it officially?
I thought we did object to that. Did we not?
No,
object?
you said, I'm not taking any position on it. I want 5 minutes to talk to my people. And then when I came back, you said, if we have 10 minutes, we can do it.
I think we're going to object to that, then. I mean, the fact that we had, up to this point, been relying on their representation And how that affects us, frankly, is we have, from playing the video where there's really functionally no additional cross, right? The cross is done on the video. And instead, we are forced to cobble together, based on the cross that was given, based on how the case may present, over lunch. That's big prejudice. That's the most important witness in the case.
So how is it a discovery violation? You knew of this witness.
It is the disingenuous nature of them presenting it in saying that she's unavailable, she's not available, and then presenting evidence to that, and then the about face at the 11th hour. Number 4 would be Sergeant Smith, and that one is based on the state indicating they're not calling him. Granted, he is listed in discovery, but in trial prep, when the parties communicate, when the court tells it pre-trial, at docket sounding, hey, who are you calling? And suddenly, we get a new one, after, or not a different answer, after they have in writing confirmed they are not calling him. That again forces us to have a cross ready.
So
Let's say,
are either side, are you able to decide which witnesses you want to call or not on the day of?
that is true, but these people were, one, not read to the jury. Imagine, Judge, for a second, if we had a RICO case with 100 witnesses. Is it not important to assess through those and determine which ones are actually going to be called? It's the same concept where if a party is telling us, they're representing to us, to the court, who they expect to call, and then with no notice saying, no, actually someone else, that prejudices us. I think there's support in 3220 for the court to address on any other matter it sees fit as the ends of justice require. That's not verbatim. I think it might be subsection J, but I have to double check. And then finally, the 5th one would be the change of address form.
Any response, State? And just before they start, what are you asking the court to do because of the accumulation of the...
Dismiss the case with prejudice, and in the alternative, the court finds that that is too harsh of a remedy to, at the very least, exclude the change of address form. And we are also, with respect to Roy, requesting a proffer.
Which I think we already said we were going to do that. All right, State.
Yes, sir. Judge, I think this goes all of this goes all the way back to the late filings that the defense made, which pretty much caused the avalanche of the discovery that was received. With regards to the 5 violations, the court has already found that there has been no ground to support any of these violations being Richardson. I would be hard pressed for the court to then turn around and find that any one of them or all of them taken together when there is no violation should be grounds for dismissal with prejudice. If the court, it seems like if the court looks at the filings that were made in this case, the motion to dismiss from the defense was made at 3:48 yesterday. And in response to that, the state filed the change of address form in discovery at 4:27. And supplemental discovery then also went out at 4:40, which is, I believe, 3 other documents. So for them to say that, we waited to the last minute, well, it wasn't until the last minute that they filed their motion. And then the state responds. They want to be able to say, well, we're going to file this motion, but we don't want you to do any work on it or look into anything so that we can get a dismissal. And obviously that's not how things can work. The whole point was they filed the motion, the state researches the motion, and in researching the motion, finds a lot of these documents that would not have even come into play had they not filed their motion at the last minute, which, as I understand it, I'm assuming 3:48 yesterday would have also been after when jury selection took place. And with regards to Officer Roy being a late disclosure, Judge, we have already indicated he is a rebuttal witness, and it is merely a courtesy that we have told them that he may testify. But we don't necessarily have to until the moment that we feel he's necessary to testify. But we did in this case in an abundance of caution. Now it's being used against us. The other exception that we take here, Judge, is with regards to Officer Oliver and the claims that that the state is being disingenuous. Judge, I wasn't here for all of the history with this case, but my understanding is that Officer Oliver, her testimony was perpetuated because she was pregnant, and over the defense's objection, court granted the order to perpetuate the testimony. The testimony was taken. My understanding was that after the testimony was done, the defense served her with a subpoena to appear. And the court then, I guess, later found out that she was unavailable, or determined that she was unavailable, and she didn't have to appear. But, Judge, due to everything that has been going on with this case, with regards to the videos and the depositions being leaked out to the media about this case, the officer has found herself in a very precarious situation because now she is being touted as an officer who has been planting evidence, and she has taken upon herself to now make herself available to confront these claims. Now counsel is objecting to her testifying. If there's a disingenuous argument here, Judge, it is that. And I would say, Judge, that with regards to Sergeant Smith, if the emails that we have in our possession from my trial partner are correct, and I believe they are, it basically says that she didn't say that they weren't calling Sergeant Smith. The email specifically says that they did not issue a subpoena for Sergeant Smith as of that date. So there has been nothing disingenuous here. If anything, the disingenuousness of the arguments are coming from the opposite side. But none of this that the defense has presented, none of the 5 violations that the court has found there were no violations for, are grounds for a total dismissal, which is the severest of sanctions for the court to take. And for that reason, Judge, I would ask that you deny the defense's motion.
Mr. Henley, is it your position that rebuttal witnesses have to be disclosed in discovery?
No. No.
Okay. All right, so I, again, going through the list, find no discovery violations. The ones that we've already discussed that I went ahead and had a Richardson hearing on and went through the prongs. I'm standing by those previous rulings. So we will proceed with our first witness. I'm going to deny the request to dismiss the charges.
And as to the lesser remedy status, we need a ruling on those as well.
I'm denying your request to suppress the address change form, and I can't remember what the other one was.
The proffer for Roy.
Yeah, I'm going to still allow the proffer.
Understood.
Because we have to find out what's going on with all of that, if it's necessary, and what he's going to say. State ready to proceed?
Yes, Your Honor, the state is ready to proceed.
Defense ready to proceed?
Yes, sir.
All right, let's bring in the jurors.
Judge, may we address something real quick? Sidebar.
Yes.
All rise, jury entering the courtroom.
I'm sorry, you may be seated. Welcome back, ladies and gentlemen. We are back on the record. Stacey Riley, defendant, is present at council table, and the jury is in the jury box. Before we proceed, it has been brought to my attention that there have been some either posts or pictures online where the media is focusing in on the screens of either of the attorneys' tables. I want to instruct the media to not focus on the attorney work product. That is not something that should be broadcast. Does the media understand? Okay. All right. State, are you ready to proceed?
Yes, Your Honor, the state is ready to proceed.
You may call your first
The
witness.
state calls Officer Kirsten Oliver to the stand.
Judge, we could approach on one other matter.
Okay. If you can come on up. If you'll just stop about right there, the clerk's going to swear you in. Thank you. You can have a seat. State, you may proceed.
Thank you, Your Honor. Good afternoon. Could you please introduce yourself to the members of our jury?
Hello, I'm Officer Oliver with the Tallahassee Police Department.
Now, Ms. Oliver, I want to talk about you as a person. Could you tell us a little bit about what you do for your job?
Yes, ma'am. So I am a patrol officer for the Tallahassee Police Department. I've been there since 2020. I patrol the streets of whatever district I'm assigned to, and I go to calls for service, I patrol for traffic stops, I look for suspicious activity, just basic law enforcement duties.
Now, I want to rewind in time. You mentioned that you've been with the Tallahassee Police Department for about 2 years. Was that correct?
Since 2020, correct.
Okay. So before you started with the Tallahassee Police Department in 2020, did you receive any education related to law enforcement?
No, ma'am.
What type of training did you receive to become a police officer?
The basic recruit training at the Pat Thomas Academy.
How long was the basic recruit training?
From January until June.
Okay. So when you were in this training program, were you trained on specific indicators or a DUI investigation?
Yes.
Okay. Can you tell us a little bit about what that training looked like for you?
Yes. So for basic DUI training, we're trained on how to find indicators of intoxication or use of substances. And that training consists of like field training, field sobriety exercises, and things to look for on a person's face.
What's your objection?
Expert testimony.
Overruled.
Field sobriety exercises, things to look for in people's face, the things that they say, and just different ways of driving and things like that.
Okay. So now that we've discussed your experience and your training with driving under the influence cases, I want to transition and talk a bit about a specific period of time. Do you recall May of 2023?
Yes, ma'am.
Now, Ms. Oliver, how long in May of 2023 were you with the Tallahassee Police Department?
The entire month of May.
Okay. At that point, though, how many years were you working there?
So from 2020, May of 2020 until May of 2023, so approximately 3 years.
And during those 3 years, did you conduct DUI investigations?
Yes, ma'am.
Okay. When you conducted those DUI investigations, were you with a field training officer?
Sometimes, yes.
Okay. So just to clarify, when you're working, starting as a police officer, do you start by working with a field training officer?
Yes.
Okay. And then once you start to get comfortable, do you transition over to your own investigations?
Yes.
Okay. So in May of 2023, would you characterize yourself as having a lot of DUI investigations under your belt?
No.
Okay. Now, I want to turn your attention to a specific date. Do you recall May 7th of 2023?
Yes.
Okay. So specifically before 2 a.m., can you tell the jury what you were doing?
So before 2 a.m., I was doing my regular patrols. I may have stopped a few cars. Directly before 2 a.m., I was back up for another officer for their traffic stop, just making sure that they were okay and safety reasons.
You said there was another officer you were with. Which officer was that?
That was Officer Muth.
Okay. Margaret Muth?
Yes.
Okay. So while you're at this different traffic stop, is there anything unusual that you notice on the roadway?
While I was on the traffic stop, I noticed a vehicle traveling behind me at a high rate of speed, and then I noticed that their headlights were off.
How fast are we talking about?
I would say faster than the speed limit, which was 45 in that area. So I would say maybe about 10 miles over the speed limit.
Okay. And I just want to be clear for the record, did you have any type of device that was able to ascertain exactly how fast he was going?
No.
Okay. So is it safe to say that that was something based on just your observation?
Objection, leading.
Overruled.
I'll ask the question again. Is it safe to say that your observation was, or your assessment of the speed was based on your observations?
Yes.
Okay. Is that something that you do in other traffic investigations or traffic stops?
Yes.
Okay. When you were at this initial traffic stop, where were you located?
I was at the intersection of South Monroe Street and Magnolia.
Okay. And I'm not sure if you covered this. The vehicle that you saw driving down the road, was there headlights on it?
No, there was not.
Okay. So now that we've talked about this vehicle that you noticed, what's your initial reaction when you see it?
I was kind of shocked. I was like, okay, let me go stop that vehicle because they don't have headlights on and they're driving too fast.
And was it dark out when this happened?
Yes.
Okay, so you said that you wanted to go stop it. Did you stop it in your patrol vehicle?
I did.
Okay. How long did it take you to catch up with the vehicle?
Several seconds, longer than the average stop. It took several streets passing until the vehicle did stop.
Okay. Can you describe to the jury the driving pattern of this vehicle?
Yes. So the vehicle that I saw was traveling without headlights on. It did was traveling at a speed above 45. When I got behind it, it was starting to slow down, but it wasn't stopping. My blue lights were on, and the vehicle was kind of swerving in and out, crossing the line into the right-hand lane next to it, and it was, kind of just going in and out of the lanes, the lane it was in, and then the lane next to it.
Okay, so you mentioned that it was swerving into the right-hand lane. When it was swerving into the right-hand lane, was there any vehicle in that lane?
Yes.
Okay, what happened there?
So there was a vehicle, next to it at one point, and they never collided or anything, but it was close to, it concerned me that they were going to hit them.
Now I want to pause for a second. We talked about your DUI training from before you started working with the Tallahassee Police Department. Were you trained to look for specific driving patterns in
Yes.
DUI? I'm sorry, yes.
Yes, I was.
Okay, so what specifically in your training were you told to look for or trained to look for driving patterns?
So with driving patterns, traveling too slow, too fast, not able to maintain their lane that they're originally in, changing lanes, excessively, and just irregular patterns of, not normal driving.
The driving pattern that you saw that evening, was that consistent with the impairment signs you were trained to look for?
Yes.
So now you put your headlights on. Did the vehicle put its blinker on?
The blinker was on, I just don't remember when it was turned on originally.
Okay. So you see the vehicle put its blinker on. Does it get over into the right-hand lane after that?
No.
Does it pull over to a shoulder?
No.
Where does it go?
It pulls into a left-hand turning lane, still slightly in the lane that it was in originally.
So now that you've stopped the vehicle, where are you located?
I'm located at South Monroe Street and Laura Lee.
What county is that located in?
It's in Leon County.
Now I'd like to transition to after you stopped the vehicle. Were you ever able to make contact with the occupant of it?
Yes, I was.
Okay. So as you're approaching the vehicle to speak to the occupant, what type of vehicle was it?
It was a white Mercedes.
And when you approach the window, do you notice how many people are inside?
Yes.
How many?
One.
Are you familiar with who that individual was?
Yes.
Can you tell us what his name was?
Calvin Riley.
Do you see the individual that you saw driving the white Mercedes in this courtroom here today?
I do.
Okay. Could you please point him out and describe him by an article of clothing?
Yes, it's the gentleman sitting over there with a whitish shirt and glasses.
Let the record reflect that the witness has identified the defendant as the driver. Now, sir, I want to pause again. So at this point, I'm going to pause again. So when you're in your DUI training course, when you're interacting with somebody in a traffic stop like this, what specific signs of impairment are you trained to look for?
So at this point, we're just face to face. We're looking for odors. We're looking for sweat on the face. We're looking for slurred speech, confusion in the way that they're speaking. We're looking for bloodshot eyes, watery eyes, anything that kind of looks out of the normal of somebody that would be, walking down the street.
Can you tell us what the defendant appeared like to you based on your training and experience when you first made contact with him?
When I first made contact with him, before all of the conversation started, I noticed that his eyes were watery, and that they were kind of bloodshot.
Was he making eye contact with you during this?
Partially, yes.
Okay. Now, I know that you mentioned that the main reason that you stopped him was because of the headlights.
Correct.
Were you able to get his headlights on for him?
Yes.
Can you tell us what that process was like for you?
Yes. So after conversation had started, I advised him of why he was stopped because he requested the information, and I advised him that the headlights were off and he was speeding. And when I went to show him that his headlights were off, I turned the dial that's in the car that turns the lights on and off, and I turned it to auto, and the lights appeared in front of us.
So after you show him that his headlights were in fact off, did you ask for any documents from him?
Yes, before I even showed him his headlights were off, I asked for his driver's license, registration, and proof of insurance.
Was he ever able to produce those for you?
No, he was not.
Can you tell us what that was like for him looking for those documents?
Yes, so when I asked for those documents, he turned over to the center console and kind of just like hovered over it, was looking, and then he turned and opened his visor in front of him, and he was pulling papers out. Things were fumbling and falling, and he couldn't seem to find what he was looking for.
Okay. I'm going to pause for a second again. You mentioned that he looked into a center console.
Yes.
Okay. So later in your investigation, or actually, did you notice any containers or cups near that center console later in your investigation?
Yes, there was a Tervis tumbler.
Okay. Were you able to determine what was in that Tervis tumbler?
Not the exact contents, no.
What, from your understanding, based on your observations and your training experience, what was in that?
I smelled it, and it smelled to be alcohol.
Okay. Now, Officer Oliver, during the course of this interaction with the defendant, did you have your body-worn camera on?
I did.
During the initial interaction, did you ever turn your body-worn camera off?
No, I did not.
Okay. So, would you recognize a copy of the body-worn camera if you saw it here today?
Yes, I would.
Let the record reflect that I'm showing opposing counsel what's been marked as State's Exhibit, or pre-marked as State's Exhibit A. Permission to approach?
Granted.
Ms. Oliver, I've just handed you what's been pre-marked as State's Exhibit A. Do you recognize this?
I do.
Can you tell us what it is?
This is my body-worn camera footage.
Okay. Did you have an opportunity to review the video footage on that disc?
I did.
Were you able to confirm if it's a fair and accurate copy?
Yes, it is.
Were you able to confirm if it was changed or altered in any way?
No, I was not.
The state moves into evidence what's been pre-marked as State's Exhibit A.
Any objection?
Objection, Your Honor, mainly sidebar.
Ladies and gentlemen, we need to take a brief recess. You can please go back to the jury room, leave your notes on your chair. Please do not discuss anything you've heard so far, and do not do any research about the case. Thank you. May be seated. All right, the defense has requested a recess to review the videos to make sure that they are the ones that have been redacted per the court's earlier order on a motion to suppress. So we are going to we're going to start at 15 minutes. If that's not enough for you to review both videos, please let the courtroom deputy know, but we're going to start with a 15-minute recess, and we will be back, let's just say we'll be back at 1:50.
Yes, Your Honor, permission to approach the witness, and also may Sheba
She can
temporarily
step down.
Thank you.
back in the record, State B. Riley, defendant is present at counsel table. Has the defense had a chance to review the videos?
Yes, Your Honor, they were not properly redacted, so we're gonna have to get those redacted. I did want to ask the court though, so I know that part of it was a motion in limine to get rid of his refusal to the FSEs. That portion has not been redacted. Did your ruling include just when he is refusing and I'm asking him, or shortly prior to that, the officers speak to each other and decide that if he refuses, they're going to be arresting him? We would argue that that's not included in the motion in limine, but we just want to be clear what your order was before everything gets redacted properly.
All right, so my order that was filed on February the 28th suppressed 3 different portions of statement from the body-worn camera, and this was all from Officer Muth's body-worn camera, because that was the only body-worn camera footage that was the subject of that motion. So this is Detective, or Officer Oliver's body-worn camera?
So, Your Honor, when we discussed the issue, while it showed Officer Muth's, they're both there, and so that's why you actually put the time that's in the top right corner, because then it would go to both cameras.
To both, right.
But what I'm referring to is point 3 on the order, which goes to the state stipulated to motion limine to exclude his refusal to perform field sobriety exercises.
Okay, so what
Wait,
statements led up to that you are asking to have withdrawn from that body-worn camera footage?
So when they ask him to do field sobriety exercises and when he says no.
Okay.
But also prior to that though, the officers speak with each other and decide that they're going to ask him to do field sobriety exercises, but if he doesn't perform them, if he refuses, they'll then arrest him.
Okay.
So I don't know if that was technically included with my motion in limine. I would argue that we would ask to keep that portion in, but I just want it clear what the court's ruling is before we have everything redacted properly.
Your Honor, if I may comment briefly.
Sure.
If it's the defense's contention that they're going to mention field sobriety exercises in its entirety and then request us to also exclude it, that would in effect be opening the door to it. The jury at that point should be able to hear more context at it. It was always the state's understanding that we weren't going to mention field sobriety exercises, even mention the words out of our mouths based on the court's ruling.
So why wasn't that redacted then?
Your Honor, that was an honest mistake. My understanding is I just, in a storm of the media with what happened yesterday, as Your Honor is aware, I'm new to this. I'm a student. I'm trying my best, and I disclosed this to Ms. Goodfellow. What happened yesterday is I took your order and I gave it to our IT people and said, hey, can you make these redactions? Not even thinking about, I just thought it was included in the stuff that was provided for the timestamps. There was absolutely no, I had no reason to believe that it wasn't redacted. In fact, I immediately sent it upstairs and I made sure to tell Ms. Goodfellow that I'm going to make this right and make sure that it was accurate pursuant to your order. It was not my understanding that she was now going to be requesting for an additional part to be kept out of that order relating to field sobrieties exercises being mentioned at another point.
Your Honor, I'm not asking for anything additional. I just want a clarification per the order since now this is an issue.
Okay, so all references to field sobriety exercises should be redacted. There are discussions about asking him to perform them and his refusal to do so because they did not instruct him as to what would happen if he refused to do so. So any of that conversation between the 2 officers about going and doing that, as well as they're asking him to do it and his responses should be redacted from the video.
Okay, thank you, Your Honor.
Okay. All right. How long do you think this is going to take? Because it is 2 o'clock and we are 2 questions into our first witness.
Yes, Your Honor. Can I just have a moment to confer with my co-counsel? Your Honor, we're already getting the redactions done for the part that we anticipate. IT is currently working on it, so it's the moment that from them leaving the vehicle, the patrol vehicle, walking over to ask him about the field sobriety exercises. I would just ask from Ms. Goodfellow what the timestamps would be from the part that she was referring to.
Do you
So
know
we can make
that?
sure to include that.
Your Honor, I'd have to go back through and check firmly, but when I was reviewing the camera footage with Ms. Hershey, I did bring to her attention that part of the portion that she was talking about redacting between the conversation and the client's refusal, there are other statements being made there that wouldn't have to do with the refusal, and so should not be included with that order.
And that's conversations that are happening between the officers
Between officers as well as the officers and my client.
and your client, okay.
My,
Yeah, so we just need to cut out stuff relating to the FSCs. So the discussion between the officers about conducting them and what would happen if he didn't perform them, and then them asking him to perform them and his refusal.
Your Honor, we would just, based on the circumstances of this, we would just request specific timestamps from the defense because we don't want to prejudice her client in any way. We would like to make sure that this is done fairly and accurately. So we would like to make sure with Ms. Goodfellow and the defense that this is what specific portions they would like excluded pertaining to field sobriety exercises. This is something that we can get done as soon as possible. It's just,
Your Honor, we would request that they play the video in front of you and then you can give them the proper timestamps, just for clarification purposes.
Do you have the ability to play it?
yes, Your Honor, I do. Or, Your Honor, it's actually up at IT right now being edited. I have the one from Officer Muse, though, I believe. Do we still have? Your Honor, I do have the Margaret Muse body cam camera, which would have the same time stamps for Axon.
Provide it to me.
I'm sorry, Your Honor?
Give it to me.
Okay.
All right, I'm going to go back in chambers and do this. I would just like to point out for the record that I signed my order about the redactions over a month ago. The fact that the video was provided to your IT yesterday is unacceptable. This is the type of thing that should have been done immediately after my order. Both parties should have had a chance to look at this and make sure that they were right. The fact that we are wasting everyone's time, including the jurors and the court personnel, and are going to be here late into the night because of this is unacceptable. be seated. Can someone please try and find the state deputy? Are they out in the hallway? Ms. Hershey, here's the disc with the edits. We're back on the record, State v. Riley. I cut it when they start talking about FSEs all the way up to when they ask him and he refuses the FSEs. There was nothing in the between that was worth playing for the jury. Now, the edits need to be made to that disc that I just gave you if you intend to introduce it, as well as Officer Oliver's. And
Your Honor, we can get that done probably within the next 10, 15 minutes.
Ms. Goodfellow, I want you to have a chance to review it to make sure that the edits have been made. Do you want them to go through the process over again with Officer Oliver and Officer Muth to have them view it to authenticate it, or are you willing to stipulate to the authentication with the new edits?
Your Honor, we prefer to lay a foundation.
Okay, so then you're going to have to show it to Ms. Goodfellow, and you're going to have to show it to the officers so that they can watch it and authenticate the fact that it is the video that you are showing in court. It is now 2:30. Realistically, this is not going to be quick. So we are going to take a break until 3 o'clock. I'm going to bring the jurors in and explain to them why. I'm not going to give them all the reasons why, but there is a delay, and that the delay is going to go even further, so that they can also prepare to be here until after 5 o'clock. Okay?
All right, you're entering the courtroom.
May be seated. Jury is present in the courtroom. We are back on the record. State v. Riley, defendant is present at council table. So I wish I could bring you all in and say that we're getting ready to start again, but we're actually need a little bit more time. But I wanted to give you all an idea of where we're at, how long this is going to take, and to give you the opportunity, if you need, to make preparations to stay here a little bit later than we thought we were going to stay. We need about another 30 minutes for the attorneys to do things that they need to do. It is very realistic that we're going to be here past 5 o'clock. If we are here during the dinner hour, we will provide dinner for you, so please don't worry about that. But if you do have dogs or a child that needs to be picked up or something that you need to make arrangements for somebody else to do and take care of for you, I want to give you the opportunity now to make those arrangements, okay? So it is 2:30. We are going to be in recess again until 3 o'clock. And then hopefully when we come back in, it'll be smooth sailing from that point on. Have any questions about the timing? Okay, thank you. Please don't discuss anything you've heard so far, and please do not look up anything about the case. And please leave your notes out here. You may be seated. I want the parties to think long and hard about any potential issues that may come up from this point forward. Discuss them during this break while you're waiting for the video to be edited so that we do not have any unnecessary interruptions. Do you understand? I'll be in recess. We are on the record for State of Florida versus Calvin Riley, 23 CT 845. Is the state ready to proceed?
Yes, Your Honor, the state is ready to proceed.
Defense ready to proceed?
Yes, Your Honor.
Okay, I do notice that we do have a lot more folks in the courtroom than we normally have, and we have Okay, so November 6, 2023.
There was a prior one that Axon link that was sent, but it did not contain the footage at issue.
It looks like the motion to suppress was filed on February 16th, 2024. And we had a motion hearing (2027). So my question is, why did it take until the eve of trial, after we picked the jury, for your office to then decide that this behavior was so egregious that it required a motion to dismiss to be filed? Why didn't you file one on November 27th, the day after you received the video and were able to review what you have been arguing is so egregious that you want this court to dismiss the charges?
So what Your Honor is inquiring goes to a trial strategy matter. As far as you're inquiring as to matters which I cannot.
So your strategy was to pick a jury and
Well,
then
as far
file
as-
a motion to dismiss?
As far as what leads to the timing is squarely a trial strategy matter. Now, I can also say I filed this motion, and I have not been on the case since November. I've been on this case this week. So that is something the court should consider as well.
Okay. When did you have a first chance to review the video?
This is my court week. I've handled upwards of 80 cases. I'm also a division chief, so I'm responsible for several other attorneys. I had the first opportunity to look at the footage in full yesterday. I promptly filed the motion.
Okay. State.
Yes, Your Honor, there's a few different matters the state would like to address regarding the defense's argument. First, under the Florida Rules of Criminal Procedure, specifically 3.190C, subsection C, time for moving to dismiss is supposed to happen before the indictment or information or before or at arraignment.
A sealed bottle, it's worse than that though, it's a sealed bottle that is
On February 16th, 2024. And we had a motion hearing
able to be heard at any time. 4 are enumerated, and the 5th is based on fundamental grounds.
As they are calling it to be. I have copies of this case, my approach and tender.
Yes, you may.
Yes, the state has copies for the defense as well.
Today, I asked you guys not to read anything related to the case. Now, you're not in trouble or anything. I just need to ask this. We can go back.
It's getting onto this, I have it on my computer, and I can show it to them right now. Yeah. Yes.
All right, we're back on the record. State v. Riley, defendant is present at council table. Is the state ready to proceed? Is the state ready to proceed?
Yes, Your Honor, we do have some matters to address.
What are they?
It's related to the issue of redaction.
Okay.
Your Honor, the state currently has the new disc being burnt. Ms. Goodfellow and I just went through this and reviewed it. We applied all the redactions pursuant to your order. She just brought to our attention that there was the final redaction on your order. It's also redacted in this video based on the timestamps you provided. You can hear the alcohol. This is where the alcohol bottle was being opened. You can hear the cracked seal, and then it briefly cuts out for like 2 seconds, and then it goes back. So the defense, they want us to remove or add back that audio now. So we're
What
trying to.
audio is that?
I'm sorry, Your Honor?
Do we know what audio is happening at that time?
Your Honor, that's Officer Oliver when she's searching Mr. Riley's vehicle. He's not present. He wasn't making any statements to her at that time. You can't hear any of his statements. Therefore, that would not be included within the motion to suppress in your order related to it. Rather, the redaction that the state had in Officer Oliver's body-worn camera actually cuts off part of the opening of the seal.
Your Honor, the seal part can be heard.
Why was it redacted?
Your Honor, we just gave our IT department the redaction list, and it was my understanding that we were supposed to redact all statements. It wasn't any. If I could just have a moment to confirm.
Your Honor, would you allow me to address the court? I know counsel was arguing this issue. But I don't know if I can shed any light on it or not, if you all don't allow.
So you have different information as to why that part was cut out?
No, I honestly, Judge, I have no information. I don't think co-counsel has any information. I think it just happened.
I'm just trying to find out if you're saying it was redacted because it was part of my order to redact that section out.
I'm assuming that is why, but they may have miscalculated. They could have miscalculated timings.
So let Ms. Hershey address it since she was addressing it. Sure. So do you have the timestamps for when it was and what it was cut out?
Yes, Your Honor. So in your order, it says there was specific timestamps based on the Axon body-worn camera footage.
Right.
And that's the sections that our IT department cut out from the video.
I understand that's what they were supposed to cut out, but what timestamps are on that section where the bottle is being opened? Because I only reviewed Officer Muth's body-worn camera, which does not have the search of the vehicle.
Yes, Your Honor. So this was the timestamp from 2/18/30 to 2/18/37. This was from your original motion to suppress order.
Correct.
That says Muth body-worn camera. It was just my understanding from the original hearing to suppress it, and I don't know if there. So that's why it looks like that happened.
Okay.
It's a period of 7 seconds, but you can visibly hear the seal cracking. It's all still there.
Well,
the only part that really is you can hear. We're not denying that there was alcohol dumped out.
it needs to be added back in. I think that was the confusion. I was only talking about the discussion that was happening on Muth body-worn camera. And I know that we were going to go back and redact any statements that were made from the defendant's body-worn camera that lined up with that. But if he was not making statements at that portion, there's an art to this. You can't just hand an order to an IT person and ask them to make the redactions. You have to check the work.
Yes, Your Honor, I understand, and I accept responsibility that was my mistake. I missed it, and I apologize to the court for that.
Okay. So are they adding that back in now?
I will reach out to the IT department and to the other assistant or the other individual who's helping us, Mr. Swan, who's helping us with that. I'm not sure what Your Honor would like to do. I'll take deference to whatever you would like to do.
So it's 3:15 now. There is absolutely no way that we are going to get 3 of the state's witnesses, if the defense chooses to call any witnesses, and if you have any rebuttal, done, I would say before 7 o'clock tonight. So then we have to do a charge conference, read jury instructions, do closings. It's going to be 8 or 9 o'clock before the jury gets the case. What do the parties think as far as, and I can't even believe that I'm saying this, extending the trial until Monday, if the jury's available?
As long as they confer.
The statement, or, we'll wait, Your Honor, until the defense confers.
Your Honor, if I may.
Yes, ma'am.
I think the demand issue has been satisfied because the jury is sworn. I think we would have, Your Honor, would have to give a pretty strict instruction about not, viewing any outside materials. But I think there is some sense to that. That way, they are fairly deciding on the evidence and not just relenting after a very long day. I think that is, we're in agreement.
Okay. State.
The state is in agreement.
All right, we're going to proceed as normal, but I just want to put that on everyone's radars that based on how the day is going, I mean, I've never experienced anything like this in 20 years of practicing law. This is unbelievable. So where are we at with redactions?
Your Honor, we'll have to add back the audio to that one video portion. My understanding from IT is that each time we do this, we have to start all from scratch. This process can take, I would say, approximately 20 to 25 minutes.
State, you need to proceed with whatever evidence you have right now.
Yes,
If you
Your
don't
Honor.
have the right disc, then you can't enter it. If you have the right disc, you can enter it.
Yes,
Let's
Your
go.
Honor.
We're bringing the jury in. We're putting the witness on the stand. We're moving forward.
All right, jury entering the courtroom.
You may be seated. If we can have Officer Oliver come back and get on the witness stand.
Yes, Your Honor, we'll locate her right now.
You can go on and have a seat. I will just remind you that you are still under oath.
Yes, sir.
Ms. Hershey, you may inquire.
Yes, Your Honor. Officer Oliver, we'll get back to the video at a later point, so I want to just walk through your investigation. So I believe earlier we left off of your initial interaction with the defendant. Is that
Yes.
correct? Okay. Could you just remind us what signs of impairment you noticed when you first approached his vehicle?
Yes. So when I first approached the vehicle
Your Honor,
before,
asked and answered.
Sustained.
Okay. So Officer Oliver, after you notice signs of impairment during your initial interaction, where do you go then?
so I take his information, his name that he provided me on a piece of paper, and I go to my car to try to verify his information, make sure he is who he says he is, and I called for backup.
Who was backup?
Backup was Officer Muth.
Is that the same officer that you were on the different traffic stop with?
Yes, it was.
How long did it take for Officer Muth to get to the scene?
Just a few minutes.
While you were waiting those few minutes, what were you doing?
I was trying to verify Mr. Riley's identification.
Okay, how did you go about doing that?
We have law enforcement databases that we can look up driver's licenses, and so I looked it up through that database.
And what was that database?
It's called David.
Can you walk us through the process of how you do that?
Yes, so on David, you can look up somebody several different ways. You're looking for a driver's license or an ID, and when you type in either their name or the actual driver's license number, date of birth, things like that, it can pull up either several different individuals or the exact individual that you're looking for.
When you did this, were you able to locate the defendant's
Objection,
information?
calls for hearsay.
Overruled.
Officer Oliver, I'll ask it again. When you were doing this, were you able to locate the defendant's information?
Yes, I was. I was able to verify it.
Okay. When you were able to verify him, did it have a picture of him?
It did.
Did it give you information about his driver's license?
Yes, it did.
Okay. So when you saw this, were you able to determine whether or not his driver's license was active at that time?
I was.
What was the result?
It said that it was suspended.
Objection,
Grounds.
hearsay.
Overruled.
Now, once you see that an individual's license has been suspended, what's the next step in your process of researching the issue?
So when
Objection, calls for hearsay.
Overruled.
So when I am determining whether somebody knows that their driver's license is suspended or they don't know whether their driver's license is suspended, because one is a criminal citation and one is just a civil fee that you pay, like a ticket. And so in my investigation, I have to find out if he knew whether or not his license was suspended at the time.
So I just want to pause for a moment. When you interacted with the defendant earlier, what did he tell you his address was?
He stated that it was 429 West Brevard Street.
Now, when you were looking at David and trying to determine whether or not he received notice of this, what was it present or available to you at that time?
It showed that his address on his driver's license was,
Objection, calls for hearsay.
Overruled.
it said on his driver's license that I was able to pull up through David that his address on his license was 429 West Brevard Street.
To your knowledge today, or to your knowledge, Officer Oliver, was that the same as his mailing address?
To my knowledge, yes.
Or today, here in today's courtroom, are you aware of a different mailing address?
Yes, I am.
Are you familiar with what that address would have been?
I don't know the exact address, but I know that it's a P.O. box.
Okay, just one moment, Your Honor.
Objection, Your Honor, may we approach?
Yes. State, you may proceed.
Thank you, Your Honor. Officer Oliver, were you able to review the defendant's driving history?
Yes.
Were you able to review a certified copy from the Department of Highway Safety and Motor Vehicles?
Yes.
If I showed you a copy of that, would you be able to recognize it?
Yes.
Let the record reflect that I'm showing opposing counsel with the pre-marked State's Exhibit B, permission to approach.
Granted.
Thank you.
Officer Oliver, I've just handed you what's been labeled as, or pre-marked as State's Exhibit B. Do you recognize this?
Yes.
Can you tell us what this document is?
So this is get the right terminology. So this is a true and correct transcript of the above named subject's driving record as taken from the official records of the file of this department.
And who is the above named subject you're referring to?
Mr. Calvin Riley, Sr.
And the last page of the document,
Objection, that's unanswerable.
Overruled.
to clarify, the last page of the document, is that from a custodian from the Department of Highway Safety and Motor Vehicles?
Yes.
Is this a fair and accurate copy of the driving record that you reviewed?
Yes.
Has it been changed or altered in any way?
None that I know of.
Okay. The state moves to enter what's been pre-marked as State's Exhibit B into evidence as State's Exhibit 1.
It'll be entered over the defense's objection as State's Exhibit 1.
Officer Oliver, I want to walk through this document with you. So on the first page, can you tell us what the mailing address was for the defendant?
The mailing address is P.O. Box 11184.
Objection calls for hearsay.
Overruled. She's reading from the document that has been entered into evidence.
I'll ask the question again, Officer Oliver. What is the defendant's address according to what is the defendant's mailing address according to the Department of Highway Safety and Motor Vehicles?
The mailing address is P.O. Box 11184, Tallahassee, Florida 323023184.
Now, I want to be clear on this. When you first stopped the defendant, were you aware of that mailing address?
I was not.
Okay, so walk us through your thought process when you were trying to determine if he had received notice of this suspension.
So when I spoke to him earlier, he said that he was coming from 429 West Brevard Street. And when I saw the address as the residential address that's listed on his driver's license, typically that is the address that you are residing at. And so when he mentioned the address, along with the address being the same on David, his driving record, I assumed that he received the notice of his suspension at that address, and therefore he knew that his license was suspended.
Your Honor, if I could just have a moment.
Yes.
Officer, when you were reviewing the information available to you, did it say that a notice was sent?
Objection. Just a standing objection for reading from the record.
Okay. It's standingly overruled.
From your understanding, based on the information available to you, was a notice sent?
Yes.
Okay. Now, I want to point your attention to the first page. I believe there's an asterisk at the bottom of it. Is there anything on that document that specifies where mail is sent to by the Department of Highway Safety and Motor Vehicles?
Give me one moment to look for the asterisk.
And officer, I believe it would be on the first
Okay. I think I found it on the second page.
Oh, okay. You can let us know.
Would you like me to read it?
Yes, please.
Okay. So it says, what an asterisk means is notices are mailed to the last address provided to our agency pursuant to section 322.251 Florida statute. In most cases, the notice is mailed 20 days before the sanction begins. However, there are some exceptions. One, when court orders a sanction, the notice is mailed after we receive the information, although the sanction is effective on the conviction date. Or two, when a law enforcement agency provides the notice upon an arrest, a notice will not be mailed from DHS&B.
Now I want to refer your attention to page 4, I believe. Could you please read to us the first entry that came from 2023 related to a suspension?
Yes, it's dated, effective date is 2/13 of 2023, and it is a personal injury protection, property damage liability suspension.
Okay, Officer Oliver, you said a lot there, so I want to break it down. You said a personal injury protection liability. Can you tell us what that means?
That is insurance.
So just to clarify, does that mean the defendant's license was suspended because he did not have insurance?
Correct.
Okay. Now you said, when did you say this was effective?
The effective date was February 13th, 2023.
When did he receive notice according to the department?
According to this, it says January 27th of 2023.
Okay. So just to clarify, the first time the defendant received notice would have been in January 2023.
Correct.
And according to the department and the record that you received, would that have been sent to the P.O. box listed on the document?
If that was the mailing address, correct.
Okay. Now, officer, I want to refer your attention to the next entry. Can you tell us about when the next time he received notice was?
It was March 13th of 2023 was the effective date, and the notice was provided February 24th of 2023.
Okay. Was that also related to the lack of insurance?
Yes.
Okay. Now I want to move to the third entry. I believe it might be on the next page. Can you tell us when the next time he received notice was?
The effective date was March 22nd of 2023, and the notice was provided March 7th of 2023.
Did you have an opportunity to review the notice that was sent to him in the mail?
No.
Did you have an opportunity to review it before today's trial?
No.
Your Honor, permission to approach and retrieve evidence?
Granted.
Permission to publish?
Granted.
And if I could have a moment, Your Honor. Your Honor, would you like me to allow the jury to have a moment to review it, or would you like me to proceed? I could
Let's
also
let them
publish.
take a look at it.
Your Honor, if it expedites the process, I can also publish it via the
Yeah,
monitor.
let's do it that way. So if we can give the item back to the attorney, she's going to publish it on the overhead projector so that you can all look at it at the same time. So the screens in front of you should turn on automatically. Just let me know when you're able to see them.
Officer Officer Oliver, are you able to see this?
Yes, ma'am.
Okay. Is this, I'm pointing your direction to the mailing address. Is this the mailing address you were referring to earlier?
Correct.
Is this where the notice would have been sent to?
Correct.
Now, for the record, I'm flipping the page to page 4. Page 3 for the record. Actually, I apologize. Page 4, Your Honor, for the record. Officer Oliver, we're referring your attention to the very last entry. Are you able to see that?
Yes.
Okay. Is this the first time that the defendant received notice?
Yes.
Okay. So would he have received notice on January 27th of 2023?
Correct.
And that was for, can you tell us what that was for again?
That was for the lack of insurance.
I'm now flipping the page to page 5. Officer Oliver, referring your attention to the first entry, is this the second notice that the defendant received in 2023?
Correct.
Objection, Your Honor, may we approach?
Yes.
Officer Oliver, I'm going to pick up right where we left off. Can you see the screen again?
I can.
Okay. So February 24th, 2023, is that the second notice that you were referring to that was sent to him?
Correct.
Now the third entry that was sent on March 7th, 2023, is that the third notice that you were referring to?
Correct.
And just to clarify, all 3 of these notices, were they sent to his P.O. box?
Yes.
Officer, can you see the screen?
Yes, ma'am.
Okay. I want to refer your attention just to when the suspension or the license would have been reinstated. So when did the stop occur in this case?
May 7th of 2023.
Now, referring your attention to the first notice that was sent. According to the first entry on here, how long did it take for the defendant to finally reinstate his license?
It says the effective date was May 26th of 2023.
So, to be clear, would the defendant have had his license suspended all the way from January all the way until May 26th?
Correct.
How long after your stop did it take for him to finally reinstate his license?
Objection.
What's the grounds?
Irrelevant. I'm outside of the
Overruled.
information.
Overruled.
Officer, I'll ask the question again. After your stop on May 7th, how long did it take for the defendant to finally reinstate his license for lack of insurance?
So from May 7th, from the stop date, all the way until May 26th of the same year.
Officer, I want to resume talking about what happened during your stop. So, after you were able to confirm that the defendant's license was in fact suspended at the time, what's your next step in your investigation?
I was waiting for Officer Muth to arrive.
Okay. Once Officer Muth arrives to the scene, what happens next?
I advised her that I believed that the defendant was under the influence, and I asked her if she would go speak with him and see if she knew the same.
So I want to pause about this discussion that you had with Officer Muth. At any point during your discussion with her, did you know anything about an odor of alcohol or anything of the sort?
No.
Did you mention anything about me not necessarily smelling anything?
I was unsure at the time.
Could you tell us why you were unsure and why you wanted to speak to Officer Muth about this?
Yeah, so I am a younger officer. I know what alcohol smells like. I've been on multiple traffic stops. I've had the overwhelming, odor of alcohol. I've had the no odor of alcohol on traffic stops. At this point, it wasn't strong enough from just standing at the window to, his face. I couldn't smell it, initially. I was unsure. So I wanted another officer, like we always do, to either confirm or deny that, hey, I don't smell it or I do smell it.
Why did you choose Officer Muth specifically to come to the scene?
Officer Muth is experienced in DUIs. She comes from another agency where she...
Objection, bolstering.
Sustained.
So, Officer Oliver, just so we're clear here, when you called Officer Muth to the scene, was your intention to receive help?
Yes.
Were your intentions to make sure you were doing things properly?
Correct.
Was it a teaching moment for you?
Absolutely.
Okay. So now that Officer Muth is at the scene, you have this discussion about your concerns. Does she go up to the defendant?
She does.
Okay. Were you present during that interaction?
I was not.
When she went up to the defendant to talk with him, separate from you, to your knowledge, was that because she was hoping or planning to see if she could also detect signs of impairment?
Objection, reading.
Sustained.
What's your understanding of why she went up separate from you?
She went up separately to have a totally different investigation. She wanted to see for herself what she had.
If I could just have a moment, Your Honor.
Yes.
Your Honor, remove sidebar.
Yes, we can.
We do need to take a brief break. I promise this one is going to be brief. So please leave your notes on your chairs and do not discuss anything you've heard so far or do any research about the case. Sorry. May be seated. All right, so all the parties are going to get together and watch to make sure that the proper redactions are made. So Officer Oliver, you could step down so that all three of you can watch the video at the same time. I'll be back in 5 minutes to check on the progress.
Yes, Your Honor.
Take a seat. Back on the record. State v. Riley. Have you all had a chance to review the disc?
Yes, Your Honor, and the issue is now resolved.
All right. Ms. Goodfellow, are you satisfied with the redactions?
With the redactions as I saw them, yes, I did not watch the whole video, so if there are more redactions.
Yeah, if there are any issues, then feel free to object, and we will address it. Okay, let's bring the jurors back in. You can go ahead and come back up and have a seat.
Your Honor, from a housekeeping perspective, if this video is about 44 minutes, that'll bring us near the 5 o'clock hour.
Okay.
Would it be your intention to continue past 5, or?
I guess after we,
All rise, you're entering the courtroom.
may be seated. Jury is present in the courtroom. Defendant is present at counsel table. You may proceed.
Officer Oliver, I know we were just talking about the information that you had about the defendant's driving with a suspended license. After you're able to determine that his license is suspended, what is the next thing that Officer Muth and you do?
After we determine that his license is suspended, Officer Muth begins the DUI investigation.
Is that also when you place him under arrest?
Yes.
Overruled.
So just to clarify, he was placed under arrest?
Yes, he was.
Your entire interaction from the moment that you met the defendant in his vehicle up until he was placed under arrest, was that captured on your body-worn camera footage?
Yes, it was.
At any point during that period, did you ever turn off your body-worn camera footage?
No, I did not.
Officer Oliver, did you have an opportunity to see your body-worn camera footage before today?
Yes.
Would you recognize it if I showed you a copy of it?
Yes.
For the record, I'm showing defense counsel what's marked as pre-marked as State Exhibit A. Permission to approach?
Granted.
Officer, I've just handed you what's been pre-marked as State's Exhibit A. Can you tell us what this is?
This is a copy of my body-worn camera footage.
And the video footage from the stop, is that the same footage that's on this disc?
Yes.
Is it a fair and accurate copy?
Yes.
From the last time that you saw it, has it been changed or altered in any way?
No.
The state moves to enter what's been pre-marked as State's Exhibit A into evidence as State's Exhibit 2.
Any objections?
No, Your Honor.
All right, it'll be entered as State's Exhibit 2 without objection.
Permission to publish?
Yes, and I'm going to read the instruction on an edited recording. Members of the jury, you're about to view a video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and consider this evidence.
Officer Oliver, I've just published it. Can you see it on your screen?
No.
No? Okay. We'll just give it a moment. I just realized I forgot to record. Just let me know when you see it.
I see it.
For the record, this is at 1 second. Officer Oliver, can you tell us in this screen frame, where are you currently?
I'm at the intersection of South Monroe and Orange,
And where are you physically?
inside of my marked patrol vehicle.
For the record, the state's going to start playing at 1 second. For the record, I'm stopping at 30 seconds. Officer Oliver, we didn't hear any audio in those first 30 seconds. Can you tell us why?
Our body-worn cameras, they capture constant video footage, but until we push the button on our body camera, it doesn't actually record. And so when we do actually push it, like you just saw, the audio started. That's because the 30 seconds leading up to it was a pre-recording of the actions, and then once I click the body camera, it initiates sound.
For the record, I'm hitting play at 30 seconds. Officer, he just said he was coming from 429 West Brevard Street. To your knowledge, what is that?
His residential address.
So based on the travel of direction that he was traveling, or the direction he was traveling, was he heading towards West Brevard Street, or was he heading away from?
Away from West Brevard.
And for the record, we're starting at 2 minutes and 9 seconds. So, officer, we just saw the part where you had to show him to turn his headlights on. What was your concern at that point?
My concern was that he didn't even realize that his lights were off.
In conjunction with his lights being off at that point, can you tell us what exactly you're seeing about him?
So I can see his eyes because he's looking at me when he speaks to me. And I can see that they're, bloodshot, glossy.
So now it looks like in this video you're about to walk away to your patrol vehicle. At that point, had he given you any documents?
He gave me one document, yes.
Was that document his driver's license?
No, it was not.
Was it his registration?
No.
Do you remember what it was?
I remember that the headline at the top left corner was some sort of LLC.
Did it have his name on it?
It did.
Did it say Kelvin Augusta Riley Sr.?
No.
Or you don't remember what if it said his name or?
It said Calvin Riley, but I don't remember if it said the full name.
Okay. Do you recall if it said an address on it?
I don't recall.
Would it help if you saw a picture of that document he handed you?
Yes.
Permission to approach? Let the record reflect on the showing opposing counsel. And now I'm approaching the witness.
Thank you.
Officer Oliver, I just handed you a document. I believe it's actually pre-marked as State's Exhibit H. Can you tell us what this is without talking about the contents?
Yes, this is a photograph from my body-worn camera.
So just a screen capture of it?
Correct.
Is it fair and accurate?
Correct.
Has it been changed or altered in any way?
No.
The state would move into evidence what's been pre-marked as State's Exhibit H as State's Exhibit 3.
Any objection?
Objection, best evidence rule as well as call for hearsay.
Overruled. It'll be entered as State's Exhibit 3.
Officer, I want you to tell us what's in that picture.
So in the picture, I'm holding a document that was handed to me. I'm standing outside of my marked patrol vehicle. I can see from what I can tell, the top left corner where I stated it said something about an
Objection, hearsay.
Overruled.
where it said an LLC. I can't see the first word, but it says rental, comma, LLC. And then normally where somebody's mailing address and who it's addressed to in the middle of the paper is Calvin Riley Sr., P.O. Box 11184, Tallahassee, Florida, and then a zip code that's unreadable.
So to clarify, this is the document the defendant gave you.
Correct.
Officer, is this address on the document the defendant gave you the same address as the one that the notice of suspension was sent to?
Correct.
Permission to approach?
Yes.
Officer, we just talked about that document. Actually, Your Honor, if I could just have him, could I actually retrieve the evidence? Permission to publish?
Granted.
Officer Oliver, can you see the screen?
I can.
Can you see the document we were just referring to, State's Exhibit 3?
Yes, ma'am.
And right here, where it says Calvin Riley, is that the name that you're referring to?
Yes, ma'am.
Also, is this the address that we were referring to just now?
Yes, ma'am.
Okay. So this would have been the same address that he received notice at?
Correct.
For the record, I'm republishing State's Exhibit 2. And I am playing For the record, I stopped at 4 minutes, 13 seconds. Officer, can you tell us what you're doing in this moment?
Yes, so at this moment, I'm trying to identify the driver with the piece of paper and the name that he provided to me through our teletype, which is like a dispatcher.
You said you were unsure, and for the record, I'm pausing at 4 minutes, 48 seconds. You said you were unsure about something. Can you tell us what you said there?
So typically to positively identify somebody through teletype, we typically have to have at least a middle initial. Sometimes they can work through it. I did not obtain a middle initial from him, and so I didn't believe that he was going to give me one because I believed at the time that he may be under the influence.
Would you have been able to obtain your middle initial if he had given you a driver's license?
Yes, I would have.
Could you have given him a citation for not having a driver's license?
Yes.
Okay. At any point in your investigation, did you cite him for that?
No, I did not.
For the record, I'm going to resume playing at 4 minutes, 48 seconds. For the record, I'm pausing at 5 minutes, 4 seconds. You just pulled up a program on your computer. What is that?
That would be David.
Is that the program you used to check whether or not his license was valid
Correct.
or suspended?
Objection, authentication, cumulative, and hearsay.
Overruled.
Okay. A screen just popped up. What is it?
This is a David copy of Mr. Riley's driver's license.
And on this, can you see his picture?
I can.
Can you see his signature?
I can.
Can you see his residential address?
It's blurry, but yes.
For the record, I'm resuming at 5 minutes and 42 seconds. Officer, you're talking to someone. Can you tell us about that?
I'm talking to Officer Muth, who arrived to help me.
Why did you ask about Brevard Street?
Because I wanted to positively know that he lived there, and that was where the suspension was sent to.
And I know we clarified this earlier. Were you accurate when you were talking about the Brevard Street with the notice?
No, because it would have been sent to the P.O. box.
And, okay. And for the record, I'm going to resume playing at 6 minutes and 46 seconds. I'm pausing at 7 minutes and 48 seconds. Can you tell us why you sat there so long looking at this program?
So the face sheet that I'm looking at now is the kind of the same thing as the paper that you were shown earlier where it shows notices were sent. Typically on that sheet, it shows if a suspension was sent and a couple of different items of information about the driver and the driver's history. I was sitting there for so long because I was looking at that page, but also watching the back of my other officer.
I believe I fast forward a few seconds. For the record, I'm at 7 minutes 48 seconds.
Objection, Your Honor, rule of completeness.
Overruled. They'll have the whole video and they can watch it back. This is just publishing. It's in evidence.
Sir, I've just fast forwarded a few seconds, just making sure we had everything. So I wanted to make sure here. Okay, I'm going to hit play and we'll watch this video. Officer, can you tell us, and for the record, I'm stopping at 15 minutes and 15 seconds. Officer, we see in this body worn camera that you just entered the defendant's vehicle. What are you doing here?
Right now, I'm searching his vehicle for further evidence.
What's the first thing you notice at this point? I'll re-ask the question. Do you notice anything about his center console?
It's closed.
How about in front of his center console?
There's a Tervis tumbler.
Something was just put back into, and for the record, I'm stopping at 16 minutes, 26 seconds. It looks like something was just put back into a cup holder. Is that the Tervis you're talking about?
Correct.
Okay. What are you and Officer Muth talking about when that was picked up?
So I leaned over and smelled the contents inside of the cup, and it smelled like alcohol to me. So I asked her to smell it as well, again, asking for another officer's opinion. And she said, it smells like alcohol. And then we put it back.
For the record, I'm going to hit play at 16 minutes and 26 seconds. Officer, can you describe to us where exactly you found this vodka bottle?
Yes, so there was a cover on the seat, as you can see, and right where your knees would sit, like behind your knees, there's a little pouch, and it just kind of opens up if you stick your hand in there, and that's where I located the vodka.
How did you know it was vodka?
It said vodka on the bottle.
When you found this vodka bottle, was the defendant already placed under arrest at that point?
Yes, he was.
What was he already placed under arrest for?
Driving under the influence.
Was there another thing?
He was also placed under arrest for driving with a suspended license knowingly.
So did this vodka bottle play any decision or play any role in your decision to have him placed under arrest for driving under the influence or driving with a suspended license?
No, because it was found post his arrest.
For the record, I'm hitting play at 17 minutes and 3 seconds. Officer, I'm gonna briefly pause. We're, for the record, 18 minutes, 18 seconds. Why do you have a phone and keys in your hand?
The defendant requested to make a phone call for his vehicle, and that's what I was doing. I was getting his phone so that he can make a phone call.
How many times did you request for his phone and his car keys?
A lot.
When you're trained for DUI investigations, were you trained on anything about suspects mentioning things over and over?
So obsessive behaviors is one of the indicators, and repeating themselves is also an indicator.
For the record, I'm going to hit play at 18 minutes, 18 seconds. Officer, we just saw you dump out some alcohol, so I want to walk through this with you. When you first found this bottle, was it your assumption or was it your belief of whether, actually strike that, what was your understanding of whether or not this bottle was opened when you first found it?
I did not know whether or not it was opened.
Did you check to see if it was opened?
When I went to open it, yes.
Did you initially think it was opened?
I believed it to be yes.
At what point did you realize that it was not open?
When the seal broke.
Did you have to hear the video footage again to know that the seal broke?
Objection, reading.
Overruled.
I'll ask the question again. Did you have to review your body-worn camera footage again to hear the seal break?
Yes, there was a lot going on at this traffic stop.
So when you dumped out this alcohol, why did you do that?
So typically when I find alcohol in a vehicle, whether it's a DUI investigation or just open container, because we all have discretion in misdemeanor crimes. We can choose whether to charge somebody with something or not. And in this case, I dump alcohol out if I find it. He was not charged with it. So my intention of dumping it out was solely to dump it out and get it out of the car. That was it.
Did you take the bottle into your vehicle?
No.
And I know we're jumping forward in time a little bit. After you put the bottle in the vehicle, who picked up the vehicle from the scene?
A tow truck.
Was it a private tow truck?
It was a rotation.
For the record, I'm going to hit play at 18 minutes and 31 seconds.
21 minutes and 34 seconds briefly. There's another vehicle there. Who is that?
That's Officer Muse patrol vehicle.
Objection, hearsay.
I'm sorry, what was the objection?
Hearsay.
Overruled.
The record I'm restarting at 33 minutes and 58 seconds.
The suspension happened on 3/22 of this year, and it said that the notice was provided on the 7th, which means that address. He is already inputted in there. History, I honestly don't really know.
I am through talking. No, you can't read none of me. I don't want to say nothing. I don't want to say nothing to you. I don't want to say nothing to you because you're switching up three different scenarios that y'all went through since y'all started me. I don't want to talk to you about nothing. Nothing. I don't want to talk to my lawyer. I don't want to talk to you about nothing. I don't want to know you read up. You just have to listen. Close the door, sir. I'm asking you, please close the door. Are you recording this? Are you recording this? Well, I don't want to talk to you about nothing. I don't want to talk to you about nothing. I don't want to talk to you about nothing. I don't want to talk to you about nothing. You trying to sugarcoat it. No, ain't no previous nothing. I am telling you this. I don't want to talk to you about nothing because what you said to me, miss, that you start me because your lights is off. And then she said she stopped me because she smelled weed. So therefore, y'all both are liars. I don't want to talk to neither one of y'all. I don't care about none of that. You can say whatever you want to say. I don't understand none of what you're saying. I don't acknowledge none of what you're saying. I am coherent with what you're saying. I have no knowledge of what you're saying. And you miss are a liar. Because I don't smoke, I don't do no drugs. And what you said that you stopped me because you smell weed. My name is Calvin Everybody Senior. I'm born and raised in Tallahassee, Florida. You know, no, don't close the door yet. Now, so you want to close the door now. I'm born and raised Leon County, Tallahassee, Florida. I'm 55 years old, and you are a liar. Did you get that rotation coming out? Okay, thank you, sir. I can have it.
For the record, the video is ended. Officer? Officer, the video just ended, and we overheard you saying something about a tow or a wrecker. Can you tell us what you were doing in that moment?
I was calling a rotation tow for his vehicle to be picked up.
What is a rotation tow?
So we have kind of like contracts with different tow companies, and we put them on a rotation. So one time this tow truck gets the opportunity to pick up a car, and then the next time it goes to the next person in line. So we just called whoever was next in line.
Was that your final interaction with the defendant that we saw?
Yes, it was.
Did you ever interact with him after you turned off your camera?
No, I did not.
Why did you turn off your camera?
Because I did not have any more interaction with him.
Now, I want to also talk a little bit more about some of the stuff we saw. Officer, after you searched the vehicle, what other signs of impairment can you tell us about that you noticed?
So the excessive talking, the aggression, the constant just yelling over us, and the just talking about the same things over and over again. Again, asking about the phone and just repetition.
Did you ever raise your voice at the defendant?
No, I did not.
We also saw in the video that Officer Muth was reading something to the defendant. Can you tell us what that was?
Objection, hearsay.
I'll sustain it. You can ask Officer Muth about it.
Yes, Your Honor. May I confer with co-counsel?
Yes.
The state has no further questions for the witness, Your Honor.
All right. Cross-examination.
May we approach?
We're going to take a brief recess before cross-examination for a comfort break. Please don't discuss anything you've heard so far. Please don't take your notes back with you, and please do not do any research about the case. After we finish with this witness, we're going to have a discussion about the rest of the day. Okay? All right, thank you. All right, you may be seated. Do we think 10 minutes is enough, or do you think 15?
I'd be on the side of 13, Your Honor.
I'll take a 15-minute recess. You may step down.
Thank you.
won't come back on until that's active.
Yeah, exactly. Okay, but I'm right.
You don't say that. Like, oh, I know, yeah, actually. Yes, sir.
Huh? Yes, that's Pittsburgh. Thank you very much. I do. No, I've got water right here. They're trying to get her right now.
Back in the record, Stacey Riley, defendant is present at council table. Any issues before we bring the jurors in?
There's no issues from the state, Your Honor.
Defense.
Nothing from defense.
All right, let's bring him in.
Your Honor, would you like Officer Oliver to be back on the
She can
stand?
go ahead.
All rise, you're entering the courtroom.
All right, you may be seated. Defense, you may cross.
Officer Oliver, you pulled Mr. Riley over for 2 reasons, correct?
Correct.
No headlights is one of them, correct?
Correct.
And you believed he was speeding.
Yes.
You were actually at another roadside stop when you saw him.
Correct.
You didn't use a radar gun.
I did not.
You didn't use any speed measurement device.
I did not.
You just assumed.
Based on my training, yes.
You left the other stop.
Yes, I did.
You got behind Mr. Riley within a few seconds.
Yes.
You actually follow him for a while without even activating your lights.
No, that's not correct.
That's not correct.
No.
So that's your testimony here today.
Yes.
And you had your body-worn camera on during this time, correct?
Correct.
To be clear, you actually followed him for a while without even activating your police lights.
Objection asked and answered.
Sustained.
I was just clarifying, Your Honor, because previously I said lights.
Okay. Ask the question.
You actually followed him for a while without even activating your police lights, correct?
Incorrect.
That's your testimony here today.
Yes.
You were wearing a body-worn camera.
Correct.
You've received training on TPD's requirements for use of body-worn camera.
Correct.
Per policy for all traffic stops, your body-worn camera is required to be on.
Correct.
You did not activate your body-worn camera until you got in your car to pull him over.
Correct.
We see you following him.
Correct.
But your body-worn camera doesn't record him driving.
No, it's on my chest. You can't see it.
There is no footage of his driving pattern.
Negative.
That's incorrect?
I'm sorry, that's correct. There's no camera footage.
Your testimony is that he swerved in the road to pull over,
Correct.
but none of that is captured on your camera.
It's not.
Objection has been answered.
Sustained.
Your testimony today is that he was swerving in and out into a right-hand lane, going in and out of lane, correct?
Correct.
In your initial report, written the morning of his arrest, all you indicated, though, was swerving.
Is that a question?
Correct? Is that all that you put in your initial report?
I don't know. I don't have my report in front of me.
Would seeing your initial report refresh your recollection?
Yes, ma'am.
May I approach the witness with her report, Your Honor?
Yes, ma'am.
Your Honor, the state would ask to see it before.
Yes, Your Honor. May I approach, Your Honor?
Yes, ma'am.
Thank you.
Is that your police report?
Yes, ma'am.
And it was written the day of the incident?
Yes, ma'am.
And on that, you are sworn to tell the truth, correct?
Yes, ma'am.
And in that, you...
Objection, improper impeachment.
I'm refreshing her
Overruled.
recollection, Your Honor. Looking at your police report now, do you still think that you put into your initial report just swerving? Is that correct?
I'm sorry, say that again.
Now you've looked at your police report. It's true that on that report, you indicated just swerving, correct?
Objection, improper refreshment.
Sustained.
May I confer, Your Honor?
Yes, ma'am.
Does seeing your report refresh your recollection?
Yes, ma'am.
Did you say anything different than what you testified here today?
Objection, Your Honor, improper refreshment again.
Sustained.
Your Honor, can we sidebar?
Briefly,
May I approach to receive the
Yes, you
report?
may.
Thank you.
Where you pulled Mr. Riley over was in the turn lane by the median, correct?
Correct.
There was no shoulder on the right for him to pull over to.
No sidewalk.
He uses his left blinker
Yes.
to indicate that he's turning to the left.
Yes.
Once the car stopped, you walk up to the car.
Correct.
Mr. Riley is cooperative.
Correct.
He is respectful.
Correct.
He follows all your commands.
Yes.
You testified that you thought his eyes were glossy.
Correct.
He's wearing glasses, correct?
Yes.
The day of, he was wearing glasses, correct?
Yes.
Today, you also testified that he had bloodshot eyes, correct?
Correct.
And you wrote a report on May 7th, correct?
Yes, ma'am.
And you swore to tell the truth in that report, correct?
Yes, ma'am.
And in that report, you never said anything about him having bloodshot eyes. Correct?
Okay. Yes, correct.
You also did a deposition, is that correct?
Correct.
In which you were sworn to tell the truth?
Yes, ma'am.
And in that deposition, you also never said he had bloodshot eyes.
Okay.
So while you're at the window, he begins looking for the items you requested.
Yes.
Correct? He gives you his name and date of birth.
Yes.
He tells you that he can't find his license.
Correct.
Actually, when you search the car, you don't find it.
I don't.
And at some point, you went back to your patrol vehicle.
Correct.
And you ran his information.
Yes, ma'am.
And you believe that he knew that his license was suspended.
Yes, ma'am.
You believe that was the reason why he didn't have a license.
Yes, ma'am.
When Officer Muth got there, you wanted her to ask Mr. Riley whether he still lived on the Brevard address, correct?
Correct.
And you saw that notices were sent to Mr. Riley regarding the driver's license suspension.
Yes, ma'am.
But you just assumed that was 429 West Brevard Street.
I'm sorry, can you rephrase the question?
You saw the suspensions.
Yes.
You saw that notices were sent.
Yes.
Today, you testified that they were sent to a P.O. box.
Correct.
But you did a deposition, correct?
Yes, ma'am.
And you swore to tell the truth.
Yes, ma'am.
And in that deposition, you repeatedly said that the notices were sent to 429 West Brevard.
Because that was my knowledge, yes.
But today, you're saying a different address.
Correct.
Because previously, you just assumed that it was 429 West Brevard.
Yes, ma'am.
Because you didn't actually see the notices themselves.
I did not.
You didn't actually see the mailing address for the notices.
No, ma'am.
You didn't see it on a physical piece of paper.
No, ma'am.
You didn't see it on a screen.
No, ma'am.
You did not see the notices at all.
No, ma'am.
called Officer Muth for backup, that's because you already suspected DUI, correct?
Yes, ma'am.
But you weren't 100% certain it was a DUI.
No, ma'am.
In fact, at that point, you hadn't even smelled anything, correct?
I was unsure. Yes, ma'am.
Now, when you were next to the car, you say that you smelled marijuana from the car. Is that correct?
Yes, ma'am.
Because you thought it was a DUI.
Yes, ma'am.
During the search, you found a bottle of alcohol, correct?
Yes, ma'am.
And that was found in a pouch on the front of the driver's seat?
Yes, ma'am.
And the bottle you found in that pouch was 20-gram vodka, correct?
Yes, ma'am.
And it was a smaller bottle.
Yes, ma'am.
When you found the bottle, you took it out, you put the bottle on the seat,
Yes, ma'am.
and you continue then to search the car.
Yes.
During that search, you didn't find any marijuana.
No, ma'am.
You didn't find any joints.
No, ma'am.
You didn't find any paraphernalia.
No, ma'am.
You didn't find any evidence of marijuana besides a smell.
Yes, ma'am.
Before finishing the search, you went back to that 20-gram bottle that you left on the driver's seat,
Yes, ma'am.
and you picked up that bottle.
Yes, ma'am.
You opened that bottle.
Yes, ma'am.
That bottle was sealed before you opened it.
Yes, ma'am.
And so you twisted the top of the bottle,
Yes, ma'am.
and you broke the seal.
Yes, ma'am.
And after you opened it, you dumped out the contents.
Yes, ma'am.
You dumped it onto the road.
Yes, ma'am.
Then you put the top back onto the bottle.
Yes.
And then you put the bottle back into the car.
Yes, ma'am.
You threw it on the passenger side.
I did.
And has that always been your testimony?
Everything that you just asked. I did not know that I opened the bottle in my original testimony.
At a pretrial hearing, you swore to tell the truth, correct?
Yes, ma'am.
And you testified that you didn't unseal it.
Objection, Your Honor.
Overruled.
Yes.
So, at that time, that was a lie.
Unknowingly, yes.
But now, you know that you did unseal it because you had the chance to watch your body-worn camera.
Yes, ma'am.
Now, Officer Muth was the other officer with you, correct?
Yes, ma'am.
She also conducted the search of the vehicle.
Yes, ma'am.
And as we keep reiterating, you've previously done a deposition, correct?
Yes, ma'am.
And during that deposition, you swore to tell the truth.
Yes, ma'am.
Has it always been your testimony that Officer Muth also searched the car?
I told you at the time I did not remember her searching the vehicle.
So, Officer Muth wasn't there when you opened the bottle.
No, ma'am.
And officers rely on each other to write reports.
Yes, ma'am.
And that's because not every officer sees everything.
Correct.
And not every officer writes a report.
Correct.
Usually there's a primary officer,
Yes, ma'am.
and they're the ones who write the primary report.
Yes, ma'am.
In this case, Officer Muth was the officer who wrote the primary report.
Correct.
And you told Officer Muth about the bottle.
Yes, ma'am.
And you told her that because she was the primary officer,
Yes, ma'am.
because she'd be writing the report.
Yes, ma'am.
And you told her about the bottle because you were using it as evidence.
I told her that there was a bottle of vodka found in the vehicle.
Hearsay.
Overruled.
I told her that I found a bottle of vodka in the driver's seat. Now, whether she used it or not as evidence, that was up to her.
But she only knows anything about that bottle because of you.
Yes, ma'am.
Objection, speculation.
Overruled.
So her entire knowledge of that bottle is based on what you told her.
Objection, speculation.
Overruled.
Yes, ma'am.
And an open liquor bottle found inside the car within reach of the driver would be a big indicator for a DUI, correct?
Yes, ma'am.
And you told Officer Muth that bottle was open.
No.
Has that always been your testimony?
I don't remember.
You did a deposition, correct?
I did.
You swore to tell the truth?
Yes, ma'am.
In that deposition, did you say something different?
I don't remember what I said about that.
Would seeing a copy of the deposition refresh your recollection?
Yes, ma'am.
Which line and page number?
63.
For the court as well, what page and line?
Your Honor, the state's going to object to improper impeachment.
What's the page and line that you're intending to use?
Your Honor, it's page 63, lines, to include the question, 4 through 7.
You can proceed with your refreshing of a recollection.
I'm searching. May I approach, Your Honor?
Yes, ma'am.
Thank you. Lines 4 through 7.
Yeah, just
Oh,
to
sorry.
yourself.
Thank you. Okay.
In that, did you say that you didn't remember your exact phrasing, but you knew from seeing her
Objection,
report?
improper impeachment.
Sustained.
Amendment confirmed, Your Honor.
Yes.
seeing a copy of your deposition, did that refresh your recollection?
Yes, ma'am.
And had you previously testified saying that while you didn't remember your...
Objection, improper impeachment, and hearsay.
Overruled.
Did you previously testify that you didn't remember your exact phrasing, but you knew that from seeing her report?
Objection, Your Honor, improper impeachment.
You need to ask it a little bit differently, but that's sustained.
Did you previously testify that you didn't remember your exact phrasing?
Correct.
But previously, you didn't deny telling her that it was open.
No, because I couldn't remember.
But you agree that she would only know that from you.
Yes, ma'am.
I withdraw my objection.
And like you said, she put that in her report.
She put an opened bottle, correct?
And she put that in her report because it was evidence.
I can't say why she put it in her report.
The report says that there is an open bottle, which she knows because of you. Correct?
Maybe.
Did you not testify earlier that the only way she would have known that it was open was from you?
Either what I said or what she assumed.
So you're denying that previously you testified that she only knew about being ordered because...
Improper impeachment.
Sustained.
A moment to confer, Your Honor. Officer Oliver, you previously testified at this trial, correct?
Yes, ma'am.
You've been under oath this entire time that you've been on the stand.
Yes, ma'am.
And you previously testified that the only way that Officer Muth would know about an open bottle was because you told her it was
Objection,
open.
asked and answered.
Overruled.
Can you
Correct?
finish your question,
That was a whole question. Do I need to say it again?
please?
You previously testified under oath that the only way Officer Muth would have known that there was an open bottle is because you would have told her that it was open.
If it was said to her, then yes, it would have been me.
And you would agree that an empty bottle would be evidence of a DUI.
Yes.
And that's an open bottle that you created.
Yes.
You're the one who made it an open bottle.
Objection, asked and answered.
Overruled.
Yes.
So you're the one who created the big evidence of the DUI.
I don't know if she used it as evidence.
In the car, you also found an insulated mug, correct?
Correct.
And that was in the cup holder?
Yes, ma'am.
And you claimed that you smelled alcohol in the cup.
Yes, ma'am.
But you didn't test the contents of the cup.
No, ma'am.
And you didn't dump out the contents of the cup.
No, ma'am.
You just dumped out the contents of the sealed vodka bottle.
Yes, ma'am.
And also in that car, you found cologne, correct?
Yes, ma'am.
And you said about how you smelled it, correct?
Yes, ma'am.
That it was a strong odor.
Yes, ma'am.
It's a policy of TPD that body cameras are on during entire and criminal investigations, correct?
Yes, ma'am.
This was a criminal investigation,
Yes, ma'am.
but you didn't have it on for the entirety of the investigation.
Yes, I did.
That's your testimony here today, that you had it on for the entirety of the investigation.
For the criminal portion of the investigation, yes.
But you turned off your body-worn camera before you left the scene.
Yes.
It was off while you continued to do things on the scene.
Correct.
It was off while you continued to handle evidence. Correct?
I don't know what evidence you're talking about.
It was off while you were dealing with towing the car, correct?
Yes, ma'am.
You had it off while you were dealing with the car that you're claiming was full of evidence of a DUI.
Yes, ma'am.
And after you turned off your camera, you were still speaking with Officer Muth and Sergeant Smith about the case, correct?
If I remember correctly, yes.
But your body-worn camera was off at that point.
Yes, ma'am.
Despite discussing important things about the investigation.
I was no longer with the defendant, so the criminal investigation was over for me.
Evidence isn't part of the criminal investigation.
It is.
And handling evidence is part of a criminal investigation.
Again, yes, it is.
And today, you previously testified just moments ago that you didn't have on your body-worn camera while you were towing the car full of evidence.
I did not
Asked and answered.
Overruled.
I did not physically tow the car. I never stepped out of my vehicle. I sat in my vehicle while the car was being towed.
You didn't have your body-worn camera on while you were making sure that the evidence, the big evidence that's in everybody's report, is handled correctly.
Correct.
And you're familiar with Apple Pay, correct?
Yes, ma'am.
So you know of ways that people can pay
Objection,
using phones.
relevance.
Sustained.
Mr. Riley told you that he paid with his
Objection,
phone.
hearsay.
Overruled.
Can you repeat the question?
Mr. Riley told you that he paid using his phone, correct?
Yes, ma'am.
And you thought that that wasn't true, correct?
No?
Or you thought it was odd.
I did think it was odd, yes.
But you know of ways that people can pay using their phone.
Yes, ma'am.
Mr. Riley never told you his address was 429 West Brevard Street, correct?
Not to me, no ma'am.
You just assumed that his address was 429 West Brevard Street.
Yes ma'am.
A moment to confer, Your Honor.
Yes.
When you asked Mr. Riley his name, he freely gave it, correct?
Correct.
And earlier today, you testified that you didn't get his middle initial, correct?
Correct.
And that you would need that for David, correct?
I don't need it for David, no.
But you testified that that's what you used for David,
That's what I use for teletype, which is the dispatcher.
for teletype. And you said that you didn't even ask him for his middle initial, correct?
Correct.
Because you thought that he wouldn't give you his middle initial,
Correct.
despite him willingly giving you his name without any problems.
Yes.
And like you've repeatedly said, the car was towed, correct?
Yes ma'am.
So it was never impounded.
Not to my knowledge.
Nothing further right now, Your Honor.
Your Honor?
Redirect?
Yes, Your Honor, beforehand, can we move sidebar briefly?
Yes.
Your Honor, if I may actually, the state's more or less referring to the or actually, we should probably move sidebar. I'm sorry, Your Honor.
All right, you may proceed.
Just a moment, Your Honor. May I proceed?
Yes, ma'am.
Officer Oliver, I want to pick up right where the defense left off. We were just talking about your body-worn camera being taken or turned off after you concluded the criminal investigation.
Objection, leading.
Overruled.
Officer, what big evidence was in this car when it was being towed?
Objection, leading.
Overruled.
I'll ask the question again. What big evidence was in this car when it was being towed?
The only evidence I know of is she mentioned the bottle of alcohol and the cup that smelled like alcohol.
Okay. Officer, was that big evidence to your decision to arrest the defendant?
No.
Okay. Let's talk about, looking aside from this alcohol bottle, let's stick to the facts. What signs of impairment led you to decide to arrest the defendant for driving under the influence?
The signs of impairment
Objection, cumulative.
Overruled.
the signs of impairment that I noticed myself was the glossy, red-shot eyes, the slurred speech, confusion when looking for documents, the way the vehicle was driving on the roadway, the swerving back and forth, the obsession speaking about the phone and other things, and then the aggression.
You mentioned something I actually want to touch basis on as well. You mentioned the glasses, or the glossy eyes.
Yes, ma'am.
When you saw the defendant, did he have glasses on?
Yes, ma'am.
Were they sunglasses?
No, ma'am.
Could you see through them?
Yes.
Could you still see his eyes?
Yes.
Okay. Now, I know you mentioned earlier that you didn't notice bloodshot eyes. Did another officer tell you about bloodshot eyes?
Objection, leading.
Overruled.
Did another officer tell you about bloodshot eyes?
Yes.
So, now I want to move to another point that you mentioned about fumbling documents. How long did it take the defendant to finally find some piece of paper with his name on it?
From the time the stop started, probably maybe a minute, minute and a half.
And again, did he produce his driver's license?
No.
Now, defense counsel asked you questions about, you believed he had knowledge because he didn't have a driver's license. Can you explain to the jury your rationale behind that?
Yes, so when somebody has a suspended, revoked driver's license and they still have it, we typically seize that and send it back to the DHSMB. So they typically do not have it after that point.
Now that we're talking about the seizure of the driver's license and all that, I want to move to the notices of suspension that we talked about earlier today. Officer, were you able to...
Objection, Your Honor, may we approach?
Yes.
Officer, I'll pick up right where we left off. Now, after, oh, I'm so sorry. Yes, I'm sorry, Your Honor. That was my mistake.
All right, you may proceed.
Okay, thank you, Your Honor. Okay, I'll pick up where we left off now. Officer, after noticing that the defendant didn't have his driver's license, were you able to confirm that his license was suspended?
Yes, ma'am.
Okay. Were you able to confirm how many times he was notified of that suspension?
Yes, ma'am.
Can you tell the jury how many times he received notices?
If I remember correctly, it was 3.
Objection, Your Honor, outside scope.
Sustained.
Can you tell us what address those notices were sent to?
The
Objection,
PO.
Your Honor, scope.
Overruled.
I'll ask the question again, officer. Can you tell the jury what address the notices were sent to?
If I remember it correctly from earlier, it's the PO Box 1118, I think 5 was the last number.
Your Honor, permission to approach to retrieve the pre-marked exhibit?
Clerk is making a copy of it. We'll go sidebar as soon as she's back to look at it.
Yes, Your Honor. Okay. Defense counsel asked you about what address you had seen at the scene. Can you tell us what originally you thought the notices were sent to?
I originally believed it was sent to the residential address on David, which was the 429 West Brevard Street,
Can you tell us why you assumed that?
because that's the only address given to us on David at the time of the stop.
Now we're here today, we're talking about a different address. Is it you who's saying that it went to a different, or to the PO box, or is it somebody else, like the DMV or the DHSMB?
Objection, Your Honor, calls for hearsay.
Sustained.
Could I just have a moment, Your Honor? Officer Oliver, do you remember reviewing the certified driving record earlier today?
Yes, ma'am.
Where did the DHSMB say the notice was sent to?
The PO Box.
Objection, Your Honor, hearsay.
That's referring to a document that's in evidence. It's overruled.
I'll ask one more time. Where does the DHSMB say that the notice was sent to?
The PO Box address.
Is the PO Box address the same as the one on the document the defendant gave to you?
Yes.
Now I want to transition over back to additional signs of impairment that we noticed after you checked for the defendant's driver's license suspension. After you checked for whether or not it was suspended, were you able to interact with the defendant again?
Yes.
When you're interacting with the defendant, can you describe to us how he smelt to you at that time?
He smelled overwhelmingly of alcohol.
When you were searching his vehicle, what did the vehicle smell like?
It smelled like alcohol and marijuana.
Now, I know there were some questions about how you didn't initially smell that when you first met him.
Mm-hmm.
How far away were you from the defendant when you first approached his vehicle?
From the defendant, I would say face to face was maybe about 2 to 3 feet.
Were you able to go inside of his vehicle?
Not at the time.
Were you able to go inside his vehicle later?
Yes.
At that later point, is that when you also realized the smell of marijuana and alcohol?
Yes.
Now, officer, I know you mentioned that you have been, or how, strike that. Officer, Was this your first time smelling the odor of alcohol?
No.
Have you smelled it before?
Yes.
Does it have a specific odor?
Yes.
Is it the same smell that you smelt that night in the car?
Yes.
Is it the same smell that you smelt that night when you sniffed the cup that you found in the center console?
Yes.
Now I'm going to transition to the second substance we just talked about. Have you smelt what marijuana smells like?
Yes.
Do you know the difference between raw and burnt marijuana smells?
I do.
So are you able, or does it have a specific odor?
Yes.
Okay. Is it the same smell that you smelled in the defendant's vehicle that night?
Yes.
In your experience as an officer, is it uncommon to come across somebody or their vehicle that has an odor of marijuana and then not find marijuana inside?
Very often, yes.
Now that we've addressed your initial observations and the driving while license suspended, I want to transition to the second part of your the second part of questioning from the defense. The defense asked you about how you went about searching the car.
Yes.
Officer, was the alcohol bottle already in the vehicle when you searched it?
Yes, it was.
Now, I know we already covered this originally, but the defense brought this up, so I want to cover it again with you. When you opened the bottle of alcohol, did you have any reason to believe that it was opened or sealed?
Objection, Your Honor, asked and answered.
Overruled.
I did not know until it was opened that it was sealed.
And I know we also talked about a suppression hearing where you found out about the seal. Did you watch your body-worn camera that night after you opened this bottle or arrested the defendant?
Not to my knowledge. I don't remember if I watched it again.
Did anyone point out to you the audio and the video until the suppression hearing?
No, not until the suppression hearing.
So, is it safe to say that when the defense pointed it out to you during the suppression hearing, that was the first time you realized your mistake?
Yes.
The defense also asked you questions about whether or not you told Officer Muth that it was open. We watched the body-worn camera footage here in court. To your recollection of it, do you recall ever hearing yourself tell Officer Muth that the bottle was open?
No.
The defense also asked you about whether or not Officer Muth searched the vehicle with you. When we watched the body-worn camera footage, could you hear her talking to you during the search of the vehicle?
Yes.
Was she also smelling the liquor in the open Tervis at the time that you were searching the vehicle?
Yes, she did.
Is it safe to say that she was helping you with the search?
Objection, leading.
Overruled.
Was she helping you with the search?
Yes, she was.
Could I have a moment to confirm? Your Honor, no further questions from the state.
Okay. Does this witness need to be retained?
Yes, Your Honor.
All right, so you may step down, but please don't leave yet.
Yes, sir.
So ladies and gentlemen of the jury, I've been told that the state has at least 2 more witnesses. So we have options. It is currently 6:20. We can push through. We can break if necessary for dinner and then reconvene and try and get this case brought to a conclusion this evening. or we can use this as a natural breaking point and return on Monday morning to reconvene. I don't know if you guys would like to go back and discuss that amongst yourselves, or if you want me to just kind of go one by one and find what your feelings are. But we have to make a decision at this point of whether we're going to push forward or take a break and reconvene on Monday. I feel bad because I told you that this would be a one-day trial, and I anticipated this to be a one-day trial, and for issues that were out of my control, it has become a very long one-day trial or perhaps a two-day trial. So would you like to go back and discuss it among yourselves? Why don't I go give you guys 5 minutes to go talk about it and then see if you can either come to a consensus, or if not, I can go one by one and talk to you about what's your preference. You may be seated. Be in recess for 5. May be seated. Back in the record, State v. Riley, let's bring the jurors in, see if they've come to a consensus.
All right, you're entering the courtroom.
May be seated. I guess first I'll ask, the jury's in the courtroom for the record. Do we have a consensus?
We do.
Okay, what would you guys like to do?
We want to come back on Monday. It's getting a little late, and we don't think that it's not going to be resolved quickly.
It's going to be a late night if we stay and push through. So I've already talked to the attorneys. They're okay with stopping at this point as well. I do have to really caution you and admonish you to please, it could be as simple as you're on Facebook and something about this shows up in your feed. So you really have to try and just limit your social media, your news consumption, anything, so that you do not accidentally read something about this case. I will ask the questions that I asked this morning again when we resume on Monday, just to make sure that you have not seen anything, but please do not read or seek out any information about this case. Okay, so we will adjourn for the evening. I still have some stuff to talk to the attorneys about, but you guys are free to go. Please be back here at 8:30 a.m. Meet the clerk downstairs at the same place that you met her this morning. I believe we will be back in this courtroom. You'll leave your notes here. We will collect them, and then we will give them back to you on Monday. Do you have any questions? Are there any additional instructions that the state would like to see?
None from the state, Your Honor.
Anything that the defense would like me to do?
None from the
Okay. Okay, thank you. You guys are free to go. All right, you may be seated. So please be back at 8:30 a.m. We can discuss anything that you guys want to discuss before we proceed with the state's next witness. I do have those documents just before you leave if you want to look at them together. I had redacted them and then had the clerk make a copy because you could still see the information on the original. So just please take a look at it before we, did I hand them back the right stuff?
Thank you, Your Honor.
I think I might have given them one thing. Okay, no, that's right. All right.
Judge, the only final issue is because this is going to Monday rather than ending today, we are anticipating subpoenaing the officers. I wanted to, on the record, ask if we can have the state accept service so that we don't have to serve them over the weekend at their homes.
This is a very unique situation. I would hope that the state would make the officers available on Monday for.
The state's intending to have them available.
And for the record, counsel has asked, and I refuse to accept personal service for the officers because they are subpoenaed for next week.
So, Judge,
Oh, they are subpoenaed for next week?
I'm not sure if one's, but we are gonna have to make sure they're present. I don't know.
I mean, we can issue the subpoena for them, Judge, to make sure that they're here for next week, but
Yeah,
they have to come in to testify for us, so.
I want to make sure that they're here because that will be an issue if one of the officers is not present and the defense would like to question them.
Yes, Your Honor, the witnesses, we plan to have them present. We need them for our burden of proof.
So that is absolutely our intention.
And are you intending to have Officer Oliver come back as well?
Judge,
We did retain her for rebuttal, so I would assume that she would be on standby. She has a young child, I don't know if she'd be in the courthouse, but if we needed her, I'm sure we can make sure she's available.
And is the defense intending to call Officer Oliver?
I believe they actually.
Hold on, I'm asking the defense a question.
we have not finalized the decision at this time, but I will say that we have subpoenaed her for next week while she was here in the courtroom. We were not able to do so for the other officers.
Okay, so you've subpoenaed Officer Oliver?
Yes.
All right, so please make sure that the other officers are here next week.
Judge, respectfully, with for looking at the McKay factors, if there's unavailability of a witness, one of the explicit factors to consider is whether they're under the control of the subpoena of the party. I know the state's saying we're going to get them there. We would like them under subpoena for defense reasons. If we can't, if they're not saying, it's fine if they're not saying they will accept service for them, but we will have to serve them at their homes. If not, we don't want to do that.
I believe that they're still here in the courthouse.
We were unable to find them. We need 5 days.
We can.
I don't know if the state can waive that on behalf of them.
Judge, I don't mind that. If they want to have an investigator go over to the law enforcement agency and drop off a subpoena for them, I'm not going to.
Through personal experience, I can tell you they will not accept them. It
Yeah.
just doesn't apply to statutory 5 days.
The agency has the because it's in statute that it has to be 5 days, so they very well might turn down the subpoena.
Your Honor, it's my understanding that they're all still here right now.
Okay.
Do we have them brought? And we have subpoenas prepared.
Can we have them brought down?
Sure.
Yes, Your Honor.
That you would redact it? I haven't entered it yet, so you guys want to approach, I can tell you what I did.
Yes.
So this is the original, but as you can see, when you redact it and you look at it in different lights, you can still see the public defender's office. So from my previous life, I know that you have to make a photocopy of this in order for the redaction to work. So that's what I did. And I know that there's objections to the document in itself, but I just wanted to make sure that there was no objections to my redactions and then copy of it to make sure that the public defender's office was not visible. Okay. You too.
8:30 on Monday? 8:30 on Monday?
8:30?
Same courtroom?
Yes.
Do we have like the lockbox that we put their devices and stuff in here in the courtroom? Can we just stick them in there? Oh, that's a tough one.
Are the officers coming down?
We already have, sir.
Okay, so they're served, everything's squared away? Okay, thank you all.
Thank you, Judge.
See you back on Monday at 8:30.
Yes, sir.